So for the first two cases, the panel has decided to change how the timer is going to run. It's going to be a straight 15-minute timer. So rather than 10 minutes and then 5 minutes for amicus, it's going to run straight down from 15. So it's up to Appellants Counsel to stop and cede time to the amicus. And at that point, it's amicus's power to reserve any rebuttal time for the appellant. If the time expires, there will be no rebuttal time. So again, it's for those first two cases, it's going to be a 15-minute running clock. The Honorable Judges of the United States Court of Appeals for the 10th Circuit, hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Thank you. Please be seated. The panel will hear 5 cases this morning. Judge McHugh is joining us via Zoom, and we will proceed with our first case, which is C1G versus Siegfried, number 201320. Counsel, you may proceed.
Good morning, Your Honors. My name is Jamie Hubbard, and I proudly represent Appellant CG. May it please the court. We are here today because a 15-year-old's juvenile attempt at dark humor posted to his private social media page on a Friday night away from school resulted in his expulsion from Cherry Creek High School. CG was at a thrift store with friends when he snapped a photograph of 3 of his friends smiling, wearing silly wigs. Inspired by a hat worn by one of his friends that came from the World War II era, CG made the unfortunate decision to caption the photo with a hashtag fashioned after a popular meme. It said, hashtag me and the boys about to exterminate the Jews. A friend of his took a screenshot of that social media post, showed it to her parents who sent it to Cherry Creek School. CG was expelled, first suspended, and then expelled for this protected speech. CG sued the school district and the individual personnel involved in the decision to expel him. And the district court dismissed that decision on First Amendment grounds, finding, using a straightforward application of the Tinker substantial disruption standard, finding that the school district had reasonably forecast a substantial disruption. Given the Mahanoy decision from last summer, the district court's decision cannot stand.
Counsel, could the school officials have expelled CG if the speech had occurred on campus?
I think under the Tinker substantial disruption standard, that would certainly apply if the speech had occurred on campus. I think then the question would be whether there was a substantial disruption or whether the school district had reasonably forecast a substantial disruption. On the record currently before the court, given that this was decided on a 12b6, I believe the answer would be no, the motion to dismiss should have been denied. But further on into the case, if the right circumstances were proven by the district that there was a disruption or there was a reasonable forecast of a disruption under the Tinker standard, the school certainly could have regulated the on-campus speech.
Well, just let me follow up on that. One thing we do have in the record at the 12b6 stage was an email from one of the parents that came in, I think, the Sunday after the Snapchat posting. And one thing it mentioned was that parents, students' concern about coming to the school based on the post and also a past anti-Semitic incident at the school. Why doesn't that together, the post and the past incident, be enough to justify discipline under Mahoney or Tinker?
So after Mahoney, then there's an open question. I believe the court clearly held that Tinker is the wrong standard, and the court cannot just look at a substantial disruption. But to clarify the factual record, that email is in the record, and the court can consider the fact that the email was sent. But I do not believe the court can consider what the parent says in that email as being true, because it's not true. There is not an established history of anti-Semitic behavior. And in fact, at the expulsion hearing, the school district dispelled the notions that the parent expresses in that email and says the parent misunderstands what had happened previously at the school.
Well, I thought the assistant principal at the expulsion hearing said that students did fear coming to the school. Isn't that part of the record?
There was no finding about any student fearing coming to school.
But wasn't that even in the complaint? Wasn't that reported in the complaint?
That the school had received the single email.
No, I'm talking about the expulsion hearing where the assistant principal talked about more than one student having some fear about coming to school.
I believe the assistant principal made an unsupported statement that yes, there had been students who feared coming to school. Under the Mahoney test, it cannot be enough that a student is offended by speech that happens outside of school. Students.
Well, it's not a student being offended. It's a student having some concern about coming to school at all.
There is no record that a student failed to come to school because of the speech that happened. In fact, by the time school started on Monday, there had been a determination made by the school that there was no threat to the school or any student at the school. The CG was allowed to drive to school, park in the parking lot, carry his backpack into the school, walk through the crowded hallways to his first period class. The school, in the era of school shootings, would never have allowed that to happen if they believed there was an ounce of a threat to the school caused by CG. The police had also investigated based on this social media speech and determined there was no threat, there was no crime committed as a result of this post. So there is no basis to find that the speech at issue in this case is a threat. There's also no basis to find that the speech at issue in this case was harassment or bullying. Those are two of the carve-outs recognized by the Mahoney court, where schools may be able to reach beyond campus and reach speech that happens purely outside of school.
But you would agree, wouldn't you, that those were examples given in the opinion, and the list is not exhaustive?
I would agree with that, but those are the examples that we have based on the Mahoney decision, and they don't apply here. This isn't a bullying or harassment case. The school gave no notice that they were considering this speech bullying or harassment. There was no policy cited to CG prior to the expulsion hearing that the school was concerned about bullying or harassment. Bullying and harassment is a very fact-intensive inquiry that requires the development of a factual record, and there simply isn't a record at this stage of the case to consider this speech as bullying or harassment.
What about threat?
There also is not a record to establish that this speech was a threat. It wasn't targeted at the school. It wasn't targeted at a teacher or another student. It was a poor attempt at a joke that was focused at a disadvantaged community. It was focused at the Jewish community. It was not focused at a particular student at Cherry Creek School who happens to be Jewish. It wasn't even focused at the Jewish students at Cherry Creek. There was nothing targeted or threatening about the speech in general, and certainly nothing targeted or threatening about Cherry Creek High School. The Mahoney decision, the reason that the Mahoney court found that Tinker cannot be the appropriate standard for when speech happens outside of school is that schools do not stand in local parentis for students. when they aren't on campus. Parents are responsible for raising children and disciplining children when they are Friday night hanging out at a local school business, or a local business, not at school. Also, the Mahanoy court recognized that students are actually, and schools, school children and teenagers in particular, are learning to be participants in our democracy, and that there are areas in which student speech is actually very important. If we think about school shootings, and we think about the Parkland survivors of the Marjorie Douglas Stoneman shooting down in Florida, we recognize that those students have created an entire social media movement that geared towards regulating gun rights. It happens on social media. They organize protests, voter registration. Students have to be allowed to express themselves. If the school is allowed to apply the Tinker substantial disruption standard, because off-campus speech may cause a disruption in the school environment because it happens on social media, then students are silenced. And the Mahanoy court recognized that students cannot be silenced in that way. Finally,
Counsel, as far as Mahanoy and your reading of it is concerned, Justice Breyer didn't say that a school's hands are completely tied when it comes to off-campus speech, did he?
no, he did not.
Well, what is your read on exactly how the majority came out in that case?
So I think to decide this case, this court needs go no further than Mahanoy. That is, the speech in this case is very similar to Mahanoy, and it is enough for this court to say that schools cannot regulate purely off-campus speech that is offensive and not a threat and not bullying and harassment. I think the takeaway from Mahanoy is that it is not just a straight Tinker analysis when the speech is completely away from school, and that's what the district court did here. So the district court decision should be reversed and can be reversed on that narrow ground. From a greater policy perspective, I think the takeaway from Mahanoy is that it's not enough, and the school cannot just look at whether their campus environment is likely to be disruptive, because that ignores the importance of student speech that may occur off campus that can disrupt the school environment, because students speak about controversial issues and they take positions about controversial issues, and that may cause discussion at school. And the fact that it causes discussion at school and may cause a school to take time away and use it as a learning process cannot be the reason that, or cannot be enough to allow schools to regulate the speech. And Your Honors, if I may, sorry, go ahead, Judge.
Let me interrupt. There's a difference that I think is significant between this case and Mahanoy, and that is that there's no suggestion of violence in the Snapchat with respect to the cheerleader. But here, me and my friends out to exterminate the Jews, it does have an element of violence, and you have a report from the teacher that some students were afraid to come to school. Isn't that a significant difference here in the facts?
It is, Your Honor, and the investigation, there was an investigation done to see if this was a threat. It was done by law enforcement, and there was an investigation done by the school, and it was determined there was no threat.
I'm not asking you whether it's speech. I agree with you, it's speech. If it were a true threat, we wouldn't be under the First Amendment at all. But that doesn't mean that just because it's not a true threat doesn't mean that there wasn't a component of violence that caused fear.
And those facts may be developed as the case moves forward. There is not sufficient facts in the record as is currently postured in front of the court right now. And I would like
you, I've got a question about your procedural due process claim. How can there be a violation for the suspensions when CG did not contest that he posted the Snapchat photo and message? What is more process going to do at that point when the basic facts are undisputed?
So the more process is that CG would have been able to come forward with information showing that he was off campus. The only notice that the school board gave, or that the school gave him, was that he had violated a policy that explicitly applies only to on-campus speech. There was no process given about bullying and harassment, and nowhere in the process.
There was no question that this was posted off campus, wasn't there? I mean, was there any indication that this was done on campus as far as the school was concerned?
No. Not that I'm aware of. And I would like to pass the rest of my time to Amicus Counsel.
Good morning, Your Honors, and may it please the Court. I am Vera Edelman, appearing on behalf of Amici ACLU and ACLU of Colorado, and today I would like to focus on the standard that the District Court applied below, and its error in applying Tinker reflexively to off-campus speech in exactly the way that it would have applied Tinker to on-campus speech. And I'd like to focus on the gravity of that error and the importance of reversing it, not only for appellant here, but also for all young people who live in the 10th Circuit. The court below clearly erred by just applying Tinker in exactly the way that it would have had the speech at issue been on campus. Mahanoy clearly forecloses that, and that is enough to reverse the court below here. But it's also important to make clear that merely foreseeable disruption can't be the standard that applies to off-campus speech. If that were the case, while that rule may make sense in school, extending it off campus would mean that students never get to have more freedom to speak than they do in the classroom or at recess. It would put protests, op-eds, just the ability to be a kid at risk. And the risks for political speech are particularly clear, given that political speech is disruptive at its best. Moreover, what exactly is disruptive or foreseeably disruptive really varies by community, by school district, by school. And so opening that standard up to off-campus speech would invite constant content and viewpoint-based discrimination for what young people say. In addition, it would rob parents of control and responsibility for their kids outside of school. And as Appellants Counsel said, it would make it harder for schools to prepare kids for a society in which offensive speech is protected. And they need to know how to live in it, how to respond to it, and how to change the minds that create it. The speech here is obviously dumb, and it is offensive, and it is ignorant. But that can't be enough to justify a school's discipline without more. At the end of the day, the school may be able to establish that, oh, I see that my time is up.
I interrupted your time. Why don't you take one more minute?
Thank you so much. It is possible that at a later stage, the school may be able to establish that what happened here was harassment or bullying, but the court will have to apply a much more tailored standard to assess whether that was the case. And the motion to dismiss stage is simply far too early to make that determination.
Thank you.
Thank you.
Good morning, and may it please the court. Jonathan Farrow on behalf of all the appellees. This case is about a school district's ability to maintain a safe and effective learning environment in the social media age, free from substantial disruption and harassment of other students. One Friday night off campus, Cherry Creek High School student CG posted a photo of
We're familiar with the facts, Counsel.
Well, I want to emphasize that the post spread over the weekend. Concerned parents contacted the police and school officials, and he was disciplined. We maintain that that discipline was lawful and that CG's complaint was correctly dismissed.
They take into account that it was dropped within an hour or two after the post with an apology?
Was that taken into account?
Yes.
I believe that from the allegations of the complaint that you can infer that the school officials knew that information at the time they made the decision to suspend.
But they had
CG.
already made the decision, apparently, before any hearing for this person. They didn't give him an opportunity to come in and explain how dumb he had been and that he was sorry and that he had taken the post down immediately and apologized to everybody.
Actually,
they didn't give him an opportunity to do anything.
Actually, Judge Kelly, I believe that the facts, as alleged by CG, show that right when he arrived at the school on Monday morning, he was escorted into the dean's office, and it was presented to him right then and there, notice that, hey, we see this
And you're
post.
suspended for 5 days.
And we're very concerned that this is creating a substantial disruption in the learning environment. And he sat in the office for hours. He had plenty of opportunity to explain why he posted
How
it.
do we know that? He might have been there for hours. How do we know he had an opportunity to explain himself?
I think it's a fair inference.
The inferences don't go your way on a motion to dismiss.
Well, and certainly he doesn't make the allegation that he never had that opportunity
Sure he
during
does.
that time.
His claim is a procedural due process claim, that he didn't have an opportunity to be heard.
Well, and I think it goes down to what he defines as an
A
opportunity to be heard.
meaningful
He's looking
opportunity to be heard.
Well, and his idea of meaningful is something way beyond what the Constitution requires. He's expecting, basically a criminal information that lays out element by element.
Wait, counsel, where do you find that? That's what he's expecting? How do you know that? Has he argued that?
I think that's the thrust of the argument.
Well, what's his argument? Where does he say that?
Well, those aren't the exact words, but that's how I take it.
Well,
And I think it's pretty beyond the basic requirements of the Constitution. Do you have some notice of what the school's charges are, what the concern about your discipline is? He was told about the post and that it was being concerned for causing a disruption in the learning
did he
environment.
get a chance to explain what his motivation was? Did he get a chance to explain the apology? Did he get a chance to explain the context? All of those things.
I mean, I don't see how you can conclude that he did not.
How can you
I mean, I'm
conclude
stuck
he
with the
did?
record, absolutely. But
Counsel, how can you conclude he did when there's nothing there to support what you're saying?
again, he alleged
Have an
that he was.
inference. You keep coming back with inferences.
Well, let's look at what he alleged. So he alleged that he was, he alleged that the post was brought to his attention and that the school was looking into how it impacted the environment of the school. And he also alleges that he sat in the office for hours. And what he doesn't allege is that he never had the opportunity to say anything. I think that's important because, again, the test of notice and opportunity to be heard at that very first stage of the initial suspension is very minimal. It's not that he was given an opportunity to call witnesses, testify, take the stand, cross-examine, have a full-blown hearing at that stage, which, by the way, he did get subsequently. He had a full...
Let me ask you this. At the time of the initial suspension, as I understand the facts, there had only been one family that had connected the school and complained. Is that right?
Yes, according to the allegations, that's correct. Yes.
And so is that enough for a substantial disruption to suspend him at that point?
Judge McHugh, I believe it's enough for a reasonable forecast of a substantial disruption, which is what the standard is and what's required. And you have to look, as I think was pointed out.
Well, the facts are that you had one complaint, the post had been deleted, and he had posted an apology, right? Those are the facts at that point.
It's a little bit more than that, and I think it's important because we have the actual email in the record, and you can read that. And look, counsel's point is well taken. We're not sitting here trying to say that the extent of the spread is something that has to be proven as a matter of fact. What we're talking about here, the issue is not necessarily how far and wide the post had actually spread Saturday and Sunday and Monday. The point is, the issue is whether those school officials were presented with information that would support a reasonable forecast. And when you look at the information that we know that they had before them based on the allegations and then the email that's incorporated in that, then that's the conclusion that the only one reasonably that can be drawn. And look at what the information in that email is.
Counsel, let me come back to the fact that we're at 12B6, and the cases you rely upon are Mahoney, Taylor, West. Those were all decided at the summary judgment stage where the record had been developed. The school had actually developed the record in that case to support their position on disruption. But here, CG alleges lack of substantial disruption. And it seems that you're asking to have inferences drawn in favor of the school, but you can't do that at 12B6. The school didn't come forward with affidavits from administrators explaining why they suspended or expelled. We just got the complaint and a few emails attached to the opposition or to the motion to dismiss, and that's it. Why shouldn't CG at least be entitled to have the record developed before the case is thrown out?
Because if you look at the face of his allegations and you take them as true, and you look at that email that's referenced and take that as true as well.
Well, are we
just
taking
the
as true?
information-
Are we taking as true as allegation that there is no substantial disruption?
I would suggest that's not a well-pled one because it's conclusory and it's rebutted by the information elsewhere in the complaint and in that email. But most importantly, again,
Where's the substantial disruption, counsel?
well, the forecast of the substantial disruption is
No,
this.
let's start with not a forecast yet. Let's go with, and by the way, the forecast case that you're relying upon from the 10th Circuit was an on-campus incident. It was a summary judgment case, and the school's already on notice that students were throwing around rubber dolls before they shut it down. It's a very different case than the one you're relying, than the one we have here. So where's the substantial disruption based on the allegations in this complaint?
All right, so CG alleges that school officials and the police were contacted about the post over the weekend. The referenced parent email referenced that the post had been widely circulated throughout the Jewish community over the weekend, was generating fear, anger, and sadness for their family, including their son, who was afraid to come to school. And their son had one.
First of all, it doesn't say afraid in the email. It says there was concern. That was the word used. You used afraid. The email says concern.
It does use the word fear.
It says concern.
I think that's the same thing.
It says concern. Do you want me to read it to you?
Excuse me for
Finally
interrupting.
expressed concern about returning to school. What does that mean? Where's the disruption? Was there any classroom disruption? Do you have any evidence at this point of classroom disruption?
Over the weekend, no, school was not in session.
Well, that's what I'm saying. Where's the disruption?
The disruption occurs during that following week.
Well, the disruption occurred as a result of the administrator's overreaction.
I don't know that that's true, but whether it is or isn't, it doesn't matter.
Well, sure it does matter, because
CG
there was no, classes were not suspended, there were no demonstrations, there were several conferences held by the administrators discussing it. Other than that, school went on as normal. There was no significant disturbance.
I don't know that school went on as normal. I would say that according to the allegations in the record, what happened is that they made a forecast over the weekend, and then the events of the following week bore out that the principal was right, that they had made a proper judgment call that was defensible and in hindsight makes sense.
You can say it all you want, but there was no disturbance,
There was
significant or otherwise.
numerous media inquiries. There were other parents that continued to contact the school
There were
with
3
concern
people.
over the week.
There were 3
And
people.
4 families made a report to the police. I think that's important. That's in the record. And as well, we get to a week later, on the following Monday, the school devotes one of their advisory periods, the entire period, school-wide, to discussing the post and hate speech.
How is that disruptive?
Is it disruptive?
Having an advisory period to discuss the post, is that really disruptive to the learning environment?
Well, it took time away from something else.
Isn't that a period that they've allocated for such discussions?
Not to discuss disruptive and harassing
No,
hate
now
speech.
you're assuming disruption to establish discussion of disruption.
No, I'm saying that the fact that all that happened a week later, I think that shows that the forecast was reasonable. Okay, that's what the point I'm trying to make.
I guess it leaves us with the question, if the school hadn't further disseminated this issue by sending every family in the school district a discussion about the email, whether they would have still been talking about it a week later.
You know, there again, I don't think that that's relevant to the test. And because the issue is, think about it this way, CG is the one who threw the rock in the pond. And that created the ripples in the pond. And the pond is the school and the educational environment. And all of that, all those repercussions made their way into the school environment, or at least the school officials.
Well, I would argue that CJ didn't throw the rock into the school, and that the school decided to throw the rock at itself. We have a situation where had nothing happened with the administration, this Snapchat would have been gone and forgotten long before they discussed it. And unlike Mahoney, they didn't take time away from an algebra class. It was a period that was dedicated to these types of discussion. So I do think it's very different than the facts of Mahoney.
I think, Judge McHugh, is really, though, what you're saying is that somehow the school is being penalized for trying to turn a very difficult situation into a positive and make it a learning. I mean, that's what schools are supposed to do. So I don't think that should be held against them.
I'm not saying they're penalized. I'm saying that it's not a disruption if the school decides to use it as a learning opportunity.
Well, and I want to point out a few things about Mahoney before my time expires, because as you had pointed out to counsel, there was no suggestion of violence in that case. When you start looking at the facts of the Mahoney decision, it's very different from what we have here. BL's post in that case was merely vulgar. It didn't cause anyone to have any concern. It didn't cause anyone to notify the police. The principal didn't send out a letter to the community reassuring it that the school was safe. There wasn't a plan that needed to be devised to get BL out of their class the next school morning so that they could come into the office and look at getting them out of the learning environment. To start the very beginning of the day, there was not press coverage that followed about school safety. And they didn't devote an entire period to that. And at most, there was like 5 to 10 minutes of discussion in the one class, as you pointed out. And that's significantly different.
Snapchat post concerned a school activity, and the post here did not mention the school.
Not explicitly, no.
It didn't mention the school, did it?
It didn't mention the school, no. But, we have to take into account that the post was posted with classmates. That's in the record. The post, one of the friends of CG who received, and it spread within the community. And again, we can argue about how much did it spread and all of that, but that's not the question. The question is, what was the information that the school officials had when they had to make that judgment call? Because that's what they have to do every single day. And Judge Matheson, you pointed out about some evidence that came in from the expulsion hearing. That's also in the record. And Assistant Principal Ulig said that the post caused, quote, extreme outcry over fear to come to school. Now, how many did they have to prove that in fact was? The point is just that's the information that they had before them.
How are we supposed to deal with that? That was that in the complaint?
It is in the complaint. It's at paragraph 72.
Right.
All right, I see that my time is about to expire.
If you have a point or two to make, I gave a little extra time, so why don't you wrap up and we'll stop at that point.
Well, I appreciate that, Your Honor. I do want to just add that it was suggested that this is not a harassment case. Well, I think it is a harassment case. The nature of those words can't be ignored. Exterminate the Jews. With those 3 historically charged words, CG invoked the Holocaust and persisting hate and violence against Jewish people. It was reasonably foreseeable that that statement would cause fear, concern, anger, sadness, disrupt the learning environment, that it would make its way from the thrift store through the ubiquitous smartphones and wireless networking that we have in this age, a reality that school districts have to deal with on a daily basis. So with that, we thank you and ask that you affirm the district court.
Thank you, counsel. Thank you to both counsel. The case will be submitted and counsel are excused.
Thank you.
As we're setting up for the next case, let me just say that our plan is to take a break after this next case. I want to make sure Judge McHugh is aware of that. So we'll take a break after this next one. All right, we'll call the next case. It is Irizarry versus Yehia. Number 21-1247. Counsel, you may proceed.
Thank you, Your Honor, and may it please the court. My name is Andrew Tudd. I represent the plaintiff appellant, Abidi Irizarry. I'd like to reserve 2 minutes for rebuttal, but if we go over, that's okay. The court should reverse the decision below and hold that Mr. Irizarry's First Amendment claim is not barred by the doctrine of qualified immunity for 2 reasons. First, the right Mr. Irizarry was exercising, the First Amendment right to film police officers in the performance of their duties in a public place from a public street, was clearly established on the night of the events in this case.
Can you
Yes,
tell
Your
us
Honor.
where your client was when he was filming?
It's not in the complaint exactly, but he was standing, as I understand it, on the actual street.
Was he in with where the police were doing a DUI check?
They had pulled over a driver, as I understand it, on a budding street, and he was actually filming from a side street that was next to it. That's my understanding of the
So he was not
scene.
in the way of any of the police activity?
That's correct, Your Honor. The police were off to the side, had pulled someone over off of a larger thoroughfare, and he was on a side street, sort of at a corner. That's my understanding of the record, and so he was not physically interfering with the stop at all, and was, as I understand it, many feet away. This is outside the record. I want to say it's not in the complaint, but I do want to return to the fact that as of May 2019, half of the federal regional circuits had already recognized in a published decision the constitutional right Mr. Irizarry sought to exercise. Those circuits cover 25 states and 5 territories and include more than 200 million people, representing 60% of the nation's population. This court should join those courts in recognizing and protecting the citizen's clearly established constitutional right to unobtrusively record a government official. Yes, Your Honor.
Let me interrupt. You didn't brief this issue though, right? You went right to clearly established.
Well, Your Honor, we believe that the right exists and that it is clearly established. So we think the greater includes the lesser. We think it was clearly established on the night in question. Because as of that night, 6 circuits had held that this right exists.
Well, would a police officer in Lakewood, Colorado be aware of what happened even on the other side of Denver?
I hold the Lakewood Police Department to the same standards as all reasonable police officers, and I think that they would be able to look at what the state of the law was, look at the fact that half of the regional circuits had reached this conclusion that smartphones are ubiquitous, that every person on the street could pull out their phone at any moment, and that they don't have the right to arrest those people.
Could we just back up?
Yes, Your Honor.
It's really a follow-up to Judge McHugh's question. So, as I understand it, the district court
Yes, Your Honor.
found that there was a constitutional violation,
Yes, Your Honor.
and then said not clearly established.
Yes, Your Honor.
And on appeal is the first part of the district court's decision that there was a violation. Is that contested?
No, Your Honor. As I understand it, it is not contested that there is a First Amendment right.
And that there was a First Amendment violation.
That there was a First Amendment violation, yes. Or that the conduct was retaliatory and would constitute retaliation. So as we understand it, this case reduces to, at this point, the only contested issue is should Officer Yehia have known that he was violating the First Amendment that night.
All right, and I understand the counter argument here is that we can't say it's clearly established because this circuit has never squarely recognized the right in the first instance.
Yes, Your Honor.
Is that your understanding?
This court, the argument seems to be, and the only argument seems to be, that because this court had not published a decision that said that there was a First Amendment right to record police explicitly, that a reasonable officer was entitled to rely on the absence of a published decision from this court.
Well, why isn't that a good argument?
Well, Your Honor, this court rejected that argument in Ullery, a recent case about this very question. The defendant in that case said that in the Westby case, the Supreme Court had left open the idea that a consensus of persuasive authority could be used to establish a clearly establish a right. But this court rejected that and said, no, because 6 courts of appeals have held that the right against sexual abuse by a guard has been established as an Eighth Amendment violation, it is clearly established law nationwide and therefore also in this circuit. And so the reason it's wrong is that the law has now become clearly established and was clearly established. Every reasonable officer would have known because it was 6-0 and because even when this court, and I want to address this, even when this court in Frazier did not announce the right and said that it wasn't clearly established, I think that was a very close question under the Supreme Court's case law. And 5 years later, looking at 2019, looking at 50% more regional circuits now having joined a consensus, no court of appeals in a published decision ever going the other way. Some of those courts saying it was obvious in light of controlling Supreme Court precedent. I think all of that on that side of the ledger put a reasonable officer on notice.
But still, the Supreme Court has not ruled on this either, right?
That's correct, Judge McHugh, but it has not, it is difficult to get a case in front of the court, the Supreme Court. The Supreme Court only grants 60 to 80 cases a year, and so far, the courts of appeals have been progressively recognizing the right. So waiting for the Supreme Court to come in and announce this nationwide is the only way for reasonable officers to be put on notice would be qualified immunity on steroids. It would be qualified immunity squared. It would, as the Ullery Court said, significantly constrict the rights of citizens in a way that qualified immunity was not designed to protect. Reasonable officers...
Don't we have,
Yes, Your Honor.
don't we have to somehow come up with a reason why it's different now than it was when Frazier was decided? Because that case said, even looking at the rules of general application from the Supreme Court, that it couldn't say the right was clearly established as of 2014.
Yes, Your
So
Honor.
you've got to show,
Yes, I think even if we bear that burden, we think we have it here because of the Turner versus Lieutenant Driver case in the Fifth Circuit, and because of the Fields versus City of Philadelphia case in the Third Circuit, which came out after 2014. They said that the right wasn't clearly established in 2012 and 2013, but they said going forward, this right is now established in the Third Circuit. This right is now established in the Fifth Circuit. And so we got 50% more regional circuits that considered the question carefully, looked at the constitutional doctrine of the Supreme Court, and reached the decision that it was a recognized right. And so 2 years later, yes, Your Honor.
does it matter when those circuits said the right was clearly established? The timing of when the right was clearly established?
It does, Your Honor. And I want to make clear, neither of those courts, neither the Third, as far as I know, or the Fifth has said that the right is clearly established. What they did was they said that going forward, starting in 2017, the right is now a right in the Third Circuit. The right is now a right in the Fifth Circuit. And so everyone takes that to mean that in those circuits it is now clearly established.
So if we made that same decision going forward, would it help your client at all?
Absolutely, Your Honor. Yes.
Because we'd say, well, starting today, it's
Yes, Your Honor.
recognized, and this event happened earlier,
Yes, yes, Your Honor.
before it was recognized.
Yes, and I see I'm running out of time, but I will tell you, yes, absolutely. It would. My client regularly engages in filming the police. He thinks that his rights were violated and that it was clear in 2019. But he, of course, would just like this court to recognize the right if it thinks that it wasn't clear yet, that going forward, police officers can't do what Officer Yehia did in this case.
Thank you.
And thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Natasha Babazadeh for the United States. To be clear, Your Honors, the government takes no position on the clearly established prong of qualified immunity. But if this court sides with plaintiff and holds that there is a clearly established right, it would proceed to address the constitutional question. But even if this court holds that the defendant is entitled to qualified immunity, we urge this court to recognize that the First Amendment protects the rights of bystanders to record police officers in public. Since this court decided Frazier in 2021, there have been 8 cases in this circuit, including this one, where district courts have issued opinions that implicate the First Amendment right to record. We cited to 3 of those cases in our brief, and since that time, there have been an additional 4 cases. So addressing this issue is timely, and it would provide much-needed clarity to the district courts. And it is also uncontroversial. As Plaintiffs' Counsel pointed out, there are 6 courts of appeals that have addressed this question and have recognized the right. I'm happy to answer any questions.
Well, if we agree with Officer Yehia on prong 2, that the law was not clearly established, why doesn't our decision in Frazier preclude us from addressing prong 1? Because that's exactly what Frazier did.
Yes, Your Honor. In Frazier, the court in a footnote declined to exercise discretion because there the parties did not dispute existence of the right. Here, the parties did dispute below existence of the right. That issue was litigated, and the district court addressed that question and provided a very thorough analysis for recognizing the right. So all of that is preserved in the record, and it is before this court. In addition to that, Your Honor, the court in Frazier in the footnote declined to exercise its discretion because it stated that it, quote, did not want to glibly announce constitutional rules. Well, the court here would not be glibly announcing a constitutional rule when there's so much by way of authority here recognizing the right. 6 courts of appeals have addressed this question. The Department of Justice since 2012,
Well,
at least 2000.
what about, we had a colloquy earlier about the fact that, at least on appeal, the question of a constitutional right has been undisputed, that we really aren't having argument about that. Would we be overstepping by just addressing that issue and saying there is a constitutional right?
Well, Your Honor, no rational defendant, because of Frazier, would dispute existence of the right on appeal.
Well, I'm asking, I think this is more of just an appellate procedure question. If the issue isn't contested, why would we be addressing it in a fulsome way?
Well, the Fifth Circuit in Turner and the Third Circuit in Fields, they both addressed the question, even though the parties didn't dispute existence of the right, and even though in both of those cases, the court granted qualified immunity to the defendant. So the court could address the question here. But also, Your Honor, the Supreme Court in Pearson provided guidance for when courts should recognize or when courts should address the constitutional question, and it should do so when rights are implicated primarily in the qualified immunity context. As is the situation here, the majority of cases concerning the right to record arise in the qualified immunity context. And so there isn't any meaningful opportunity to really develop constitutional precedent regarding this issue outside of this context, unlike, for example, the Fourth Amendment, where rights are constantly raised in criminal cases, and courts in 1983 actions can rely on those criminal cases. I would like to leave some time for plaintiff for rebuttal. And then to conclude, Your Honor, the United States urges this court, if there is no further question, urges this court once and for all to recognize that the First Amendment protects the right of bystanders to record police officers performing their duties in public. Thank you.
Good morning, and may it please the court. My name is Alex Storachik, and I represent Lakewood Police Agent Ahmed Yehia. I'm going to begin by picking up on sort of a thread that was throughout the questioning of Appellant's counsel, which is this idea that the establishment of the right somehow is precluded by whether or not there's an actual constitutional violation. And in this case, there is no establishment of the right within the 10th Circuit, nor within the U.S. Supreme Court. And many
Well, what
groups,
about the Ullery case that counsel mentioned?
I'm not sure how that applies, because in that case, I don't believe there was a question of the establishment of the right as to whether or not, and I was addressing specifically as an appellate procedure, whether or not the establishment of the right can exist when the constitutionality of the action is not being disputed. So my understanding of Allery was that,
Well, if you're not disputing that there was a constitutional violation here, didn't the right exist under that concession in 2019?
whether or not the right existed and whether or not it had been established as present within the circuit are two different questions. And whether or not the,
Well, but counsel, if you're saying that there was a constitutional violation when this incident occurred in 2019, how can there be a violation unless there was a right?
well, and I understand the question, Your Honor.
Well, then what's the answer?
Because it's a different inquiry. The inquiry isn't whether or not there was a violation. The inquiry is whether or not a reasonable police officer was on notice that his actions were a constitutional violation. Whether or not he within,
Okay, so now we're to prong two, and the appellant's relying on out-of-circuit cases.
yes,
And in Ullery, this court said that we can rely on out-of-circuit cases to find clearly established law. So what's your response to Ullery?
well, my response to Allery is that whether or not we can establish that that it's clearly established law also doesn't get into whether or not the contours of that right have been clearly established. What we're talking about is a police officer on the street making a decision about the actions he's going to take, and not just whether there's a clear constitutional violation, but whether or not his specific actions represent a violation of the
Well,
Constitution.
driving a car at the person who's trying to film the event?
Well, again, taking the facts as alleged in the complaint,
Yes.
what the district court found was that those actions weren't alleged by the plaintiff as a constitutional violation.
Not sure I follow that.
What the district court said is, we're taking the plaintiff's allegations as he stated them. And what he stated is, I was obstructed from filming. I was unable to film due to this police officer's actions. And as a result, my constitutional rights were violated. Both in his complaint and in his briefing, he does not allege that these later actions, the allegation that he had a car driven toward him, created that constitutional violation.
Did he allege the car being driven toward him in the complaint?
He did.
Well, then why can't that be considered?
What the district court's ruling was that what I'm going to do is look at specifically what he alleged and what he says, this is what caused my constitutional violation. This is what stopped me from being able to engage in what I'm describing as a constitutionally protected right. And I was unable to do that because of this officer's actions by standing in front of me and shining a flashlight at me.
Yeah, you're parsing the complaint, but the complaint was pro se, wasn't
It
it?
was.
And don't we have to give the pro se complainant a little leeway on how he's pled the case?
We certainly do. But there's a distinction between giving leeway and actually contradicting his own arguments. His own arguments, both in his briefing and in his complaint, say, this is what created my constitutional violation. I don't believe a district court has to go through the complaint and search out any potential cause of action. Now, one other point that I wanted to make in addressing the whole issue is that what we're looking at from a 10,000-foot level is whether or not a reasonable officer is on notice that his actions will violate the Constitution, but yet we have such disparate groups as the First Amendment Scholars, the National Police Accountability Project, the United States of America, all urging this panel to establish the right. The sole reason the United States of America is here is urging this panel to establish the right. And what plaintiff appellant is saying,
Well, the United States isn't taking a position on clearly established law. Does that mean we shouldn't recognize clearly established law?
maybe I'm misunderstanding the United States position, but my understanding is The United States is urging this panel to
At least
at least.
recognize the right.
Right, to recognize the
And they
right.
aren't taking a position on clearly established law.
Right.
Counsel for Mr. Irizarry is asking us to recognize clearly established law. It's squarely before us.
Right. But that's a step further. It's a step further beyond recognizing the right.
It's really the only contested issue on appeal.
I don't disagree with that. But
Look, excuse me, let me ask you, as I understood your argument, and I want you to correct me if I'm wrong, is that even if we look at all these cases from other jurisdictions and we say they clearly established a right, your argument is the facts here are so different that they didn't establish a right that would clearly have put on notice a police officer that this behavior violated that right. And let me be more specific. The other cases, they have their recordings confiscated or they're arrested or the recordings are deleted. And here there's the shining of the flashlight and the driving the car and making noise. Am I understanding your argument correctly?
well, assuming in arguendo that the right has been clearly established, that doesn't end the inquiry. I'm not conceding that the right has been clearly established, but that doesn't end the inquiry because we still have to look into the contours of what these other cases do. We have to look at what an officer, understanding these out-of-jurisdiction cases, which creates an issue in and of itself, whether or not that officer would then know, okay, if I do this, I'm going to violate this person's constitutional rights. Now, we're talking about out-of-jurisdiction cases, and that's a step further than in-jurisdiction cases, which do then provide officers notice, yes, this is a constitutional violation. But as noted by Judge McHugh, those other out-of-jurisdiction cases involve arrests, involve detentions, none of which are alleged in this case because they did not happen. So yes, there is a distinct factual difference between those out-of-jurisdiction cases and the case at bar. So going beyond that, I think what we're also identifying is what was articulated in White, which is that there has to be a case identified where an officer acting under similar circumstances was held to have violated a constitutional right. And going through Appellant's brief, there doesn't seem to be a case on point that shows those exact, or not those exact, but similar actions by an officer that would then tell Officer Yehia, you can't do this. You're violating someone's constitutional rights.
Well, given that this was a 12...
Let me,
Excuse me, go ahead, Judge.
go ahead, I'm sorry.
Given that this is a 12...
Well, seniority, you go.
Given that this was a 12B6 dismissal,
Yes.
Shouldn't the court at least have permitted the complaint to be amended? To be more specific, if that's part of the problem?
And what the district court found was that
They couldn't find anything on a 12B6.
Right. Well, perhaps poor choice of words, Your Honor, I apologize. What the district court ruled was that any amendment would be futile because what this plaintiff is alleging is these actions, the standing in front and the shining of the flashlight, violated my constitutional rights.
Well, they could amend it to include speeding the car at him, couldn't they?
What the district court was looking at was the specific four corners of the complaint and then the briefing by the plaintiff and saying, I'm basing my complaint on this. And so we're getting into that area between whether or not we have to liberally construe a pro se briefing or whether or not we can parse through and create sort of causative elements or causative action out of whole cloth. And in this particular instance, given the way the complaint was written and given the briefing as presented by plaintiff, we would be then searching through and finding any cause of action, not just liberally construing, but creating them out of whole cloth.
All right.
And now let me ask you my question, which is the allegation in the complaint that Officer Yehia drove his car directly at these people. Doesn't that rise to the level of it being so egregious that any officer would know, kind of like the Styling Hope Taylor cases?
Well,
I mean, obviously, a police officer knows you can't assault somebody with your vehicle.
and I would concede that. The question then becomes, what is the alleged motivation for that, right? And is the motivation to create a constitutional deprivation? Which then gets back as to whether or not Officer Yehia was on notice that there was a constitutional right established in this jurisdiction to film police officers in their duties, whether or not there was proper notice from within this jurisdiction, whether or not that right had been clearly established at that point.
Well, as I understand it, you've conceded the right exists.
I've conceded the right exists, but what I haven't conceded is whether or not Officer Yehia was on notice of that right, which is a distinctly different inquiry.
And my question is, there are some cases where the conduct is so egregious that the Supreme Court has said, we don't need clearly established law because everybody knows you can't try to drive your car over someone who's exercising their First Amendment right. Isn't that this case based on the allegations in the complaint?
It is not. And again, the distinct difference is not the alleged egregiousness of the actions. It's the alleged motivation for the action and whether or not Agent Yehia was on notice that there was a constitutional right to film police officers engaging in their duties, and whether or not his actions, as alleged, were motivated by a intent to deprive Mr. Irizarry of those constitutional rights. So it's not that the actions are so egregious that it automatically gives rise to a cause of action. It's what the motivation for those actions are, as alleged, and whether or not Agent Yehia, again, in looking at controlling precedent, knows, or, well, not Agent Yehia, whether or not a reasonable police officer is on notice that this is a protected constitutional right within this jurisdiction, and he can't then take actions as a result of that. And if there are no further questions, I will cede the rest of my time.
Could I just, I want to go back to this motivation point that you've been making. I mean, Officer Yehia was called to the scene, wasn't he? At least as alleged in the complaint, because of the filming that was going on.
As alleged in the complaint, yes.
Well, that's what we have to work with, right?
Right, and I'm not conceding, I'm not disputing that.
Okay. And why isn't it a fair inference then that running the car at Mr. Irizarry was motivated by the activity that Mr. Irizarry was engaged in?
I would agree that that's a fair inference. However, what I would dispute is whether or not Agent Yehia is on notice that what the activity that Mr. Irizarry was engaged in was constitutionally protected activity. Stated otherwise, in order for us to all be here to have a 1983 case, there has to be a constitutional violation, as we all know. And so, if Agent Yehia is not on notice that he's violating Mr. Irizarry's constitutional rights, then there's no cause of action. It's not just...
Okay, but I guess where I'm having a problem with this is that if it's uncontested that there was a constitutional violation and the theory of the constitutional claim is retaliation, doesn't that mean that at least the motivation element of that claim has been established?
Qualified immunity still requires that officers be put on notice.
No, I understand the notice part, but the violation itself has the motivation element, and everyone right now, I think, has conceded that there was a violation. So there was motivation. And what you're saying is he has to know what his motivation was? Is that?
What I'm saying is, he has to be aware that his actions are constitutionally violative.
Okay.
It's not enough just to have motivation to do an action. You have to have motivation to violate a constitutional right.
I understand your argument. Thank you. Thank you.
So will
One
you
more
indulge
question.
me? So if he were allowed to amend his complaint so that it was a violation of his bodily integrity when he drove the car at him, then you'd be fine with that?
I'm not sure how to answer that, and the only reason I say that is that there was nothing alleged in the complaint that addressed any of those issues. There was nothing alleged in the complaint that indicated that Mr. Irizarry felt that that was a violation. And so we're pretty far afield from the complaint as it was originally alleged. Now, I don't want to speculate as to whether or not had he thought he suffered other injury, he might have had a proper cause of action. I'll just note that we're very far afield from what Mr. Irizarry's original cause of action are.
Thank you.
Thank you. All right, thank you, counsel. We appreciate the arguments. Was there any rebuttal time for? Oh, I'm sorry. You have a minute 16. I'm glad I asked.
Thank you, Your Honor, and I'll try not to go over. I really just want to point to the complaint, pages A10 and AA11. The way it is pleaded is that Officer Yehia comes to the scene, begins obstructing and harassing and intimidating the plaintiff and his companions. And then these are verbatim. Yehia then returned to his cruiser, sat back in it, threw it in drive, then drove right at the plaintiff and Mr. Brandt and sped away. Yehia then performed an illegal U-turn and gunned his cruiser directly at Mr. Brandt, swerved around him, stopped, then repeatedly began blasting his air horn at Mr. Irizarry and Mr. Brandt. Yehia was ultimately instructed to depart the scene due to his disruptive and uncontrolled behavior. On the next page, it says, Yehia's unprofessional, unlawful, and unreasonable conduct deprived plaintiff of his rights to freedom of the press secured by the First Amendment of the United States Constitution. And that's because he pleads that he's actually a journalist. He's not just an ordinary citizen. That is enough to construe certainly a pro se complaint as alleging that all of the actions, not just coming and physically getting in front of Mr. Irizarry, not just shining his flashlight, but then speeding at him, gunning his cruiser and blasting his air horn, were all designed to prevent him from filming because he had to turn to address what was happening, but also instill significant fear. This is a deadly weapon. And I agree that driving a car right at someone is tantamount to pulling out a gun and pointing it directly at them. It should have been obvious to Officer Yehia that driving his cruiser at Mr. Irizarry violated his constitutional right to film the scene. Appreciate the time. We urge you to reverse.
Thank you, counsel. We appreciate your arguments this morning. Case will be submitted, and counsel are excused. We'll take a short break. Yeah,
We just want to join. So I don't know if I need to make that statement in the record or.
Maybe.
I mean, alternatively, I'd be happy to answer questions. Obviously, the second appeal deals with me personally with respect to sanctions, so I'd be happy to answer questions.
I would just, at the beginning of your argument, just take a moment and say, the second case will be argued just by this.
Yeah, and I'd be happy to address any questions.
Yeah. And then you can just have a seat here for the second case. She'll just take it from there.
All right, I can do that.
Okay, thank you. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
All right, our next case this morning is Integrated Associates versus Pope. We also have Integrated Associates of Denver versus Pope, but the first one is number 21-1019. And just for the record, the second one is 21-1319. We'll start with the first case. Counsel, you may proceed.
Thank you, Your Honor. I would like to reserve 3 minutes of my time for rebuttal. May it please the court. My name is Jennifer Gokenbach, and I represent the appellants in this case, the Integrated Associates and the Integrated Associates of Denver. These are parties I've represented since the beginning of this dispute with the appellee, Ryan Pope, which came about in 2016 as a result of the initial lawsuit that was filed by the appellee in state court. The appeal before you is focused narrowly on whether the That case filed in 2016, let me back up, ultimately ended up going to an arbitration proceeding. And I'm going to talk to you more about some of the specific factual events that occurred prior to that proceeding. But the appeal before you today is focused narrowly on whether the arbitrator's ultimate award of damages in the arbitration, including penalties and attorney's fees under the Colorado Wage Act, was in excess of the arbitrator's authority under Section 10A4 of the Federal Arbitration Act.
Well, isn't there a distinction to be made between an attempt by a third party or a second party to compel arbitration of a wage claim, and when the person himself or herself agrees to go to arbitration on that wage claim? Whereas one is a lawsuit, one is an arbitration claim.
Sure, and
In this case, as I understand it, you all initially sought to compel arbitration on everything. And he raised the statute that, well, you can't do it on my wage claim. And the court upheld that.
correct, yeah.
So the rest of it goes to arbitration, and then he says, okay, now you can, I'll throw my wage claim into the same deal. So what's the problem there?
Correct. So the issue on appeal is whether or not that decision, which was the initial decision, the pre-arbitration decision on the arbitrability of the claims by Mr. Pope, whether that decision is somehow mooted or somehow waived, essentially, by Mr. Pope then bringing in the wage claim in arbitration. And our position is that decision that was made by Judge Kane after the parties fully and fairly litigated the arbitrability issues, that decision is not mooted by the arbitration. That decision continues to prevail.
Why?
Because it was a decision that was reached by
Well, it was a decision reached based on a particular statute and a particular set of facts.
Correct.
But now we've got a different set of facts. We've got an arbitration proceeding going, and we have the person, Mr. Pope, says, well, go ahead and take my wage claim in as part of it.
Sure.
Now, why shouldn't he be able to do that?
Because of what Mr. Pope essentially asserted in the arbitration with respect to that wage claim. So,
No, he asserted in the suit to compel that you can't get him into court in a lawsuit on a wage claim because it's exempted from by statute. Isn't that correct?
correct. He argued to
Right.
Judge Kane that that claim is not subject to arbitration because he has non-waivable rights under the Colorado Wage Act. And so
Okay.
Judge Kane agreed and said, I
Right.
agree, the wage claim is exempt from arbitration
Right.
and not subject to arbitration,
Right.
but your other 7 claims are subject to
Right.
arbitration.
Right.
The way this case became complicated, or rather unusual, is when Mr. Pope unilaterally decided to dismiss the wage claim that he had pending before Judge Kane. There was no agreement between the parties with respect to that dismissal. That came as a unilateral action by Mr. Pope. Then there was nothing proceeding at all. There was
Before
no
Judge Kane.
before Judge Kane or in arbitration. There was nothing. He dismissed his wage claim with Judge Kane. There had not yet been a demand for arbitration filed, so there was nothing pending. Then 8 months later, he files the demand for arbitration, which is essentially a copy of his complaint
Right.
that was filed, plus an additional claim for specific performance for 33% of my client's entities. And of course, I'm not representing to this court that my clients opposed arbitration. We wanted to go to arbitration, which is what we argued.
Well, then why isn't your argument waived? Why isn't this argument waived?
Why isn't our argument waived? And that's what I'm getting to is.
I mean, you can't go through arbitration, even if Judge Kelly wasn't absolutely right that there were different issues. One was mandatory arbitration against the party's will, and the other is voluntary arbitration. But even if that weren't the case, you can't participate in an arbitration and then after you get an award you don't like, say the arbitrator didn't ever have jurisdiction over the claim.
So my response to that is really two parts. The first part is there are facts in this case that I included in the briefs that evidence that although the respondents were willing to proceed to arbitration, they asserted counterclaims against Mr. Pope, and one of those counterclaims was frustration of the arbitration process because that was a contractual provision in the agreement at issue. And then in response to that claim, Mr. Pope filed a reply, and in that reply he said, well, I'm not exposed or liable to any damages for frustration of the arbitration process because Judge Kane agreed with me. And he attached a copy of Judge Kane's order saying which essentially said the wage claim was not subject to arbitration.
By a third party, or by somebody against the wage earner.
Okay.
That's the statute.
Well, I'm interpreting Judge Kane's order, his order, which says not that Mr. Pope possesses a right to decide whether or not he wants to go to arbitration. Judge Kane's order, the plain language of the order says the Wage Act claim is not subject to arbitration. It is exempt from arbitration because of the statute that of the Colorado Wage Act, the section 84121, which says any agreement, written or oral, by an employee purporting to waive or modify such employee's rights in violation of this article shall be void. So Judge Kane cited not that Mr. Pope possesses, a right to, excuse me, I'm gonna get it, drink of my water. Judge Kane's order, in my reading of it, doesn't say that Mr. Pope possesses the right to decide whether or not he wants to go to arbitration on the claim. My reading of Judge Kane's order is far more expansive than that, and that's the basis for this appellate issue, is that was a final decision by Judge Kane, and it didn't get changed on appeal by either party. So Well,
I thought that the decision was that you could not force the employee to arbitration on a wage claim.
No, that's not my reading of Judge Kane's order.
That's what Judge Kane said. That's what the statute says.
I don't see that anywhere in Judge Kane's order. All I see in Judge Kane's order is that the statutory wage claim is not subject to arbitration, is exempt from arbitration, and he cites the Lambden case, which is the Colorado Supreme Court case addressing it, and he cites to section 84121, which says any agreement, written or oral, purporting to waive the rights under the statute.
The rights of who? The rights of the worker.
Right, any agreement written or oral by any employee purporting to waive or modify such rights in violation of this article. And so my position isn't so much about whether that order by Judge Kane is correct or not, but that is the order that governs the parties in this case. And unless that order was modified on appeal.
Judge Kane wasn't faced with this issue. This wasn't a case where the wage earner was voluntarily trying to arbitrate a wage claim. That wasn't what the judge was looking at in Pope 1. The judge was considering, as Judge Kelly has said, whether you can force a wage earner into arbitration against his will under the statute, and the court said you can't. That has nothing to do with the subsequent arbitration proceedings where you went ahead with the arbitration that was voluntarily filed by Mr. Pope, and then after you got a decision, you said it's beyond the scope of the arbitrator's jurisdiction.
And the reason that we've taken that position is based on our reading of the Pope order, not based on, I guess.
Even if you were, even if you were correct on the Pope order, which it sounds like at least two of the panel think you're not, you still have a huge waiver problem. You
And-
participated in the arbitration all the way through to a decision you didn't like before you challenged the arbitrator's jurisdiction.
And so I would like to address that because as this court knows in the US Supreme Court decisions and in first options, in other cases as well, if you put the issue of arbitrability before the arbitrator, then potentially you are consenting to the arbitrator deciding that gateway arbitrability issue, which in this case was decided pre-arbitration. So there's a problem and a complexity in raising that a claim that was previously ruled non-arbitrable, that we want the arbitrator not to arbitrate that claim or decide whether or not to arbitrate that claim. Instead, both parties put Judge Kane's order in front of the arbitrator. And the arbitrator, for some reason, just concluded that all of the claims were subject to arbitration. But as I stated, Mr. Pope himself argued in his pleadings to the arbitrator that res judicata applies to essentially immunize him from any assertion or claim that he frustrated the arbitration process, which led to 17 months of litigation or 17 months of nothing before arbitration.
Counsel, Mr. Pope, on this very issue, Mr. Pope cited a case in his briefing, Clay versus United Health Group, and pointed to, in the brief, a footnote. It says, an important point is that as used in this opinion district court's order, the term non-arbitrable simply refers to a claim that a plaintiff cannot be compelled to arbitrate. It does not necessarily mean that arbitration of such a claim is prohibited or illegal. A party may attempt to arbitrate a non-arbitrable claim. But if this is done without the other party's consent, the result is a legal nullity. But here, your client consented to have this arbitrated.
Well,
because Mr. Pope said, I think let's just do it all. I want the wage claim part of the arbitration. And then your client went through the arbitration, litigated the issue. Why doesn't that resolve this? And could you speak to this particular case?
Sure. In the Clay case, and in particular in that footnote, that Clay case involved physicians who were suing a whole host of parties, Prudential, insurance companies, Cigna, and then a whole host of additional third parties that were not parties to the actual agreements that had the arbitration provisions. So they had RICO claims, and they had conspiracy claims, they had aiding and abetting claims that were being asserted against both parties to the arbitration agreement itself and non.
Could you speak to the footnote, which
Correct.
essentially says that someone standing in Mr. Pope's shoes, if he consents to arbitration, then the issue can be arbitrated.
And the way I would respond to that is, again, by going back to the Judge Kane order, which governs this case, which says that essentially an arbitration agreement cannot be made between an employee and an employer to arbitrate a wage claim. Because according to at least my reading of Judge Kane's order,
Yeah, but you brought a motion to compel
Correct.
him to arbitrate.
But we lost on that in front of Judge Kane, so that's why his decision governs. We lost that argument.
You didn't lose on the wage claim.
We lost the argument. Yes, Judge Kane ruled against us on our motion to compel. He said the wage claim is not subject.
Okay,
Yeah.
I had that backwards. But all he said is that Mr. Pope can't be compelled.
And I would say the language of his order does not
How about
say
the
that.
language of your motion? It was a motion to compel.
Correct, which I understand, presents an argument of equitable estoppel because we argued that before Judge Kane. But because Judge Kane ruled against us and entered a final order, that is somewhat like judicial estoppel. I mean, our prior argument doesn't trump the fact that we lost that argument before Judge Kane, and therefore his order rules this issue that is between the parties and continues forward.
I understand your position. Your time is up.
I think your time is up.
It is, I'm in the red. Thank you, and we would ask that this court vacate the arbitration award with respect to the Wage Act damages.
Good morning, may it please the court. I'm Matt Molinaro, appearing on behalf of the appellee, Ryan Pope. Integrated Associates in this case demanded that Mr. Pope arbitrate his wage claim. Ultimately, after the court held that he could not be compelled to arbitrate his wage claim, he acquiesced, and in the instance of efficiency, chose to bring his wage claim before the arbitrator. He voluntarily submitted his claims to arbitration, and he partially prevailed at arbitration. Integrated Associates cannot now change course and seek to overturn the decision on the basis of lack of jurisdiction when it participated in full. It didn't raise the argument in response to the demand for arbitration. It didn't raise the argument before the arbitration hearing itself started. And it would have been simple to raise the issue at any point, and that may have been sufficient to preserve it for review, but they opted to totally omit it from the arbitration at all.
Counsel, what do you do with the language from the district court's ruling on the motion to compel? The wage claim was quote unquote exempt from arbitration. I think that's what counsel is, or at least one of the things that counsel is focusing on. Could you speak to that?
Yes, Your Honor. I think the other language in Judge Kane's order is instructive. Towards the end of the opinion, Judge Kane used the phrase that Mr. Pope is guaranteed a right to a trial in court. In the same way, a criminal defendant may be guaranteed a right to counsel. That doesn't mean the criminal defendant cannot waive the right to counsel. It means that they are permitted an attorney if they so choose. And there's no distinction here. In terms of it being exempt, I don't see a distinction with that phrasing. I think what that would mean is that it's exempt from being compelled to arbitrate. And I think that was what Judge Kelly was hitting on before, is that there's a pretty big distinction between being compelled to arbitrate and electing arbitration. In her oral argument here, Ms. Gokenbach called Mr. Pope's decision unilateral, but it was nothing of the sort. Integrated Associates, again, had every opportunity to oppose that decision during the arbitration itself. There's no evidence that they did anywhere in the record. I think the other big distinction that's important here is who picks to assert the right. And it's Mr. Pope's right to assert his right to trial. It's not for Integrated Associates to assert his right after the fact. And there's nothing that suggests that an employer can basically get the benefit of having a second trial on the basis that the employee had previously tried to oppose arbitration. There's no authority that suggests an employer can assert the employee's rights under the Colorado Wage Claim Act. I'm not aware of any authority that supports that. And again, the Lambden case, that's the Colorado Supreme Court case that is cited by Judge Kane, states that the defendant in that case cannot be enforced, let me start that over. The language of that case is that the employee could not be compelled to arbitrate. The opinion says that the Wage Claim Act, quote, allows Lambden to litigate rather than arbitrate. It continues on that the Arbitration Agreement and the Wage Claim Act cannot be enforced against the employee. And because Judge Kane relied on that opinion, it's clear that he is also applying Lambden in the same way.
Well, counsel, I have a question that's sort of off the brief here. How does the federal court have jurisdiction in this case?
I'm not sure I understand the question. In what sense?
In the sense that I don't know that there's diversity. And I don't think that under the Arbitration Act, the enforcement provision, the court can guess and by gosh that there is diversity and if there's no diversity, there's no jurisdiction.
It's my memory that the Federal Arbitration Act creates a federal question that confers jurisdiction on the federal court.
Well, I think that's not correct.
Oh, okay.
Unless there's a federal question. There's either federal question or diversity. And what's the federal question? And this might flow over into the other case. I'm just not sure, but I think you're all going to be arguing that also.
Well, I don't think that's an argument that was brought up, and I don't think I was particularly prepared to discuss that issue today. And I think that's the answer. We could submit supplemental briefing on that issue.
We must look at from our own standpoint.
Appellant is the one who removed this case to federal court.
Right.
Mr. Pope did not initially file in federal court. Or sorry, there were two separate actions. Mr. Pope initially filed an action to enforce the arbitration agreement in state court that was removed by Appellant.
Right.
Appellant filed this one directly in federal court.
Well, now we're here on a petition to modify or set aside the award. And I think there's got to be jurisdiction, not from the beginning, but at least for this point.
Sure, I don't, off the top of my head, I don't believe there's any claims that implicate a federal question. I believe the claims were garden variety, breach of contract, and under the Colorado Wage Claim Act.
Okay.
And the court briefly referenced Clay during Ms. Gokenbach's oral argument, and I want to clarify that Clay was a case that was cited by appellants. Appellants attempted to rely on Clay as their best and primary case in their briefing on this issue. But as Judge Matheson observed, the footnote's very clear that Clay does not support appellant's position, and actually, in fact, supports Mr. Pope's opinion. I'd also note that the Clay decision, even if the court were inclined to rely on it to support appellant's argument, it's out of circuit and non-binding authority. There is on-circuit binding and dispositive authority, mainly in the form of the Lewis versus Circuit City case. The Lewis versus Circuit City case directly addressed the question of whether an employee may waive their right under a no-waiver statute in the same way that was at issue with Mr. Pope. It squarely held that the employee gave up that right by fully participating in the arbitration. And appellant's standard would create an absurd result here, where the employer then has a greater right to insert the employee's right after arbitration than the employee. Lewis instructs that Mr. Pope has no ability to participate in the wage claim and then bring an appeal afterwards to disclaim the arbitration because he lost. It is important to note that he did partially lose on his wage claim in this action. He didn't get all of the wages that he asked for. He didn't get all of the penalties that he asked for. And yet he did not bring an appeal seeking to set aside the judgment so that he'd get a second chance for a better claim, because the 10th Circuit law is clear and dispositive on this point. The best language from Lewis just points to the equities of the situation, that it would be unreasonable and unjust to allow a party to challenge the legitimacy of the arbitration process in which they voluntarily participated over a period of several months. What's happened here is precisely what Lewis prohibits. The appellant waited until it lost at arbitration to reveal its objections. There's no supporting authority for that conclusion. It solely depends on what is a misinterpretation of Judge Kane's order. Judge Kane's order did not decide the issue that is presented here, whether appellant, the former employer, can assert Mr. Pope's rights. It did not foreclose Mr. Pope's ability to consent to arbitration by participation. There's a distinction between Mr. Pope participating in arbitration and a prospective waiver in the contract that would compel arbitration. Again, the compel mandatory decision is the one that Judge Kane decided. He did not decide whether Mr. Pope could fully participate in the arbitration and thereby waive his wage claim. And I think it also bears attention that appellant started with 4 different arguments here against the arbitration award. It asked the court to review on mere evidentiary error, that the arbitrator admitted what is a demonstrative exhibit, summarizing Mr. Pope's damages. There's nothing in the record to support that exhibit was even timely objected to, what the exhibit itself looks like, or what the underlying discovery responses looked like in terms of its support. The record is quite bare on that point, even if this court were inclined to accept it. And I think that's what's particularly compelling about the district court's order below. It clearly states that appellants didn't actually even prove evidentiary error in this case.
Now, this is on the issue of modification.
Sure, I think they're all intertwined, and it's alluded to in the brief, and I just wanted to be clear that those issues are so clearly in Mr. Pope's favor. And that's important because this lack of jurisdiction argument was a very small portion of the initial motion to vacate. It's a new argument that has largely been constructed after the district court denied appellant's motion to modify or vacate the arbitration award. I think the bottom line here is that appellants clearly waived their right to object to the subject matter jurisdiction of the arbitrator. Subject matter jurisdiction is not even an appropriate phrase to use because, as Judge Kelly stated, that's something a federal court must assure itself of at all times. It is not something that an arbitrator must assure itself of at all times. There's no basis for an arbitrator to raise that issue without the parties requesting it. It would be simply unjust to allow appellants to now seek reversal of Mr. Pope's wage claim victory just because they lost. They sat idly by and waited until Mr. Pope won to pull this trump card out of their pocket in attempt.
Has Mr. Pope sought to confirm the award in this case?
Yes.
And is that like a counterclaim here?
Well, as I stated here originally, what happened here, the procedural background of this case is a bit messy. He filed first with the motion to confirm in state court.
Well, but we're well past that.
Right.
Well past that. Now we've got an arbitration and a decision in Mr. Pope's favor, and we have a motion in this court or in the district court to modify or reverse the arbitrator's decision. Now, did Mr. Pope, has he got a counterclaim to confirm the award that he received?
He did not bring it as a counterclaim in this action because the motion to confirm is in a separate action.
Okay, where is that pending?
That is also in the District Court of Colorado. We had requested that the cases
It's in the district court where?
The District Court of Colorado here.
Federal district court or state?
Yes, that's
Okay.
correct.
Okay. But that's not before us at this point.
That's correct, Your Honor. That case has stayed pending the outcome of this appeal.
Okay.
And unless the panel has any further questions, I'll yield the rest of my time.
Thank you.
Thank you, counsel. Is there any rebuttal time?
Okay, next case.
Next case, we'll consider 21-1019 as submitted, and we'll proceed to 21-1319, Integrated Associates of Denver v. Pope. I understand that Ms. Cohen is joining us via Zoom. Good morning.
Good morning, I am, Your Honor.
All right, who is arguing first on this one? Is it?
Your Honor, hold on one second. Ms. Gokenbach is not going to argue. She just joined in the arguments, so I will be the one to do the arguments.
Thank you. You may proceed.
And can the court hear me? I just want to make sure the court can
Coming
hear me.
through loud and
Or the
clear.
panel, I should say. Can the panel hear me?
Yes.
Okay, all right. Ms.
Before
Gokenbach.
you get into your main argument, I want to highlight an issue that Judge Kelly touched upon earlier, because I have some real concerns about whether there's any federal jurisdiction. It appears to have been based on diversity, but I think there are very serious questions about integrated associate of Denver's principal place of business. If you go back and you look at the assertions about that, they are fluid. They change in the various pleadings, and it looks to me like the principal place of business was Denver, and in fact that's stated in the pleadings until they stop doing business, and that creates a big problem in terms of knowing where their citizenship is for purposes of diversity that no one's dealt with. Now, I'm guessing you haven't thought about this issue. I just wanted to highlight it because I think the panel is going to need some supplemental briefing on that issue. Feel free to respond if you're prepared, but I just wanted to make sure everybody understands that we've got some concerns about it.
So, Your Honor, I am not prepared to answer that because it was not an issue that was raised by the district court below as one of the issues going forward. And so I'm not prepared to be able to address it at this time. If the court would like that either for me in this argument or for Ms. Gokenbach in the other case, or both of us, then we can provide supplemental authority if that's what the court would like. And I don't know if the panel heard me that I'm going to be doing the argument and Ms. Gokenbach has joined in the argument, but we're not splitting our time. So I would like to start out with first of all, may it please the court, I am Nancy Cohen, and thank you for allowing me to do this by Zoom. But I have gotten COVID and I don't think any of you want me to be there. And so the question is, did Ms. Gokenbach act reasonably and not vexatiously when she filed on behalf of her clients the motion to vacate the arbitration award that primarily dealt with the wage claim? And as you heard Ms. Gokenbach argue in the other case, Ms. Gokenbach relied on Judge Kane's decision in which Judge Kane said, this is a statutory claim, and even though integrated associates wanted to compel arbitration, you're not allowed to compel arbitration. And so she relied on that decision as she went through. Her motion to vacate the arbitration award had to do with really three issues. One is whether the arbitrator allowed the wage claim to go forward without considering Judge Kane's order, even though the arbitrator did look at the order and understood that Judge Kane said it was not subject to arbitration. Two, whether or not the court should have allowed or awarded attorney's fees without a hearing. And that issue was not on appeal in the other case, because if the court rules that the wage claim couldn't go forward, that's going to be mooted and accept itself. And then whether or not the argument about Exhibit 37, which summarized the lost wages under the Colorado Wage Act, Ms. Gokenbach in the arbitration objected to that, objected to it based upon the rules of Federal Rules of Evidence, which everybody agreed applied. And in fact, the district court in the order denying the motion to vacate found that she had objected to it. So really the question is, in filing this motion to vacate, was it unreasonable and vexatious that Ms. Gokenbach made the argument that she believed that the wage claim could not be subject to arbitration?
What is
That
our-
really is what,
Counsel, what is our standard of review in reviewing this particular issue of sanctions?
it's under 1927, it is an abuse of discretion.
All right.
That is the standard of review.
Counsel, I'd like you to respond to a passage in Mr. Pope's brief on this issue. Mr. Pope writes that, and I'm quoting, he incurred most of his attorney fees responding to the arguments Ms. Gokenbach abandons on appeal. Could you respond to that?
Well, Ms. Gokenbach abandoned two arguments. She abandoned the argument about the attorney's fees, but in a way she abandoned that because it wasn't necessary, because if this panel finds that the wage claim should not have gone forward, then it doesn't matter whether there was a hearing or not. She really didn't abandon the issue about Exhibit 37, and she has that in her brief. So the fact that she made some strategic decisions in this brief with respect to what the court did in the underlying case, it isn't costing Mr. Pope any more money in this case. And really what the issue is whether the court should have entered fees against Ms. Gokenbach when it wasn't even clear in the original order that the fees were against Ms. Gokenbach, because Mr. Pope never filed a separate motion for sanctions. He put his request for fees
Well, that's not, and let me interrupt you there because that kind of bothered me in the way this was briefed. He did in fact file a separate motion and an affidavit in support. He filed it after the court said, I'm willing to entertain a motion for fees. He had originally included it in his motion, but there is now a separate motion and affidavit in the record, and I found it surprising that that wasn't referenced.
Well, this is the issue though. The court had already found he was entitled to fees and then directed Mr. Pope to file a motion for the amount of attorney's fees. But the decision about whether or not Mr. Pope should get fees was based upon what he had filed in the response. It wasn't based on the motion.
He represented in a brief that he never filed a motion for fees, and that's just not true. And the court indicated it would entertain his motion, and then he filed a motion and an affidavit in support, correct?
Well, that's not the way I read the order. The way I read the order is that she said he's entitled to fees, and then said you can file a motion for the amount of fees. To me, those are two separate issues. She had already made the decision that he was entitled to fees and that he may then file a motion for the amount. And that's exactly what he did. He filed a motion for fees on what the amount of fees he was entitled to. So I look at that, Judge McHugh, as two separate issues.
Well, you would agree with me that it's not completely transparent to say he never filed a separate motion for fees.
I guess saying it's not transparent, and perhaps I wasn't as clear in my opening brief in terms of that, because what I was really talking about is what he had put in his original response, and not the fact that the court said, okay, you're entitled to fees. now file a motion telling me how much of the fees you wanted. And I could have made that clearer. So I apologize to the panel if that wasn't clear on that. But the whole idea is if you're asking for a sanction, that you need to file a separate motion. And he didn't file a separate motion. He did put it in his response. What the separate motion on the motion for fees was a motion saying, this is how much I'm entitled to. And he did say how much he was entitled to, and then had an affidavit that said his fees were reasonable. So that's why, Your Honor, I look at that separately in terms of going forward. So the court then entered in the motion, in the order on the motion to vacate, the court said, yes, Mr. Pope is entitled to fees, but didn't even make it clear who was against, which is why Ms. Gokenbach filed the motion for reconsideration, because she didn't know who the fees were against, and saying under 1927, it couldn't be against her client, and the district court agreed and said, then the fees are against you, Ms. Gokenbach. And that is how it went through. But in terms of looking at whether or not Ms. Gokenbach should be sanctioned for making an argument relying on a district court opinion, she wasn't acting unreasonably in saying she believed that that opinion did not give the arbitrator subject matter jurisdiction. Now, this panel may disagree in the other case and say, no, there was an equitable estoppel. This panel may do it, but at the time when she is making her argument under the motion to vacate, she believed that it could not, it was subject matter jurisdiction and it could not be waived. And so you have to look at what she was looking at the time, even though you may not agree with the argument that she made. It doesn't mean that the argument was frivolous, and it doesn't mean that the argument lacked time or lacked merit at the time that she was making it. And when you look at the Lewis versus Circuit City case, which was referenced in the other case, it certainly was referenced in this case, one that's under the Kansas law, not under Colorado law. It concerned a contract. It didn't concern a statutory claim and whether or not an arbitrator has subject matter jurisdiction. But even in the Lewis versus Circuit City case, this panel found that even though the arguments lacked merit, that they weren't frivolous and would not order fees against the attorney for making the arguments that he did when he filed a brand new case, totally ignoring the arbitration case. So I believe that the Lewis v. Circuit City case is helpful in this case. What I would like to do is...
Counsel, didn't the court in Lewis, though, review the sanctions de novo, and here we're on abuse of discretion review?
I think the court did review the sanctions de novo based upon the way that the case had come in, because Mr. Lewis had filed a brand new case. And whether or not there was issue preclusion when he was going through that. So he had filed a brand new case, and he didn't even mention the arbitration and didn't mention that he had lost at the arbitration.
Well, no, my only point is that we're in a different posture here in reviewing the sanctions award. We're viewing for abuse of discretion. I think you agreed with that earlier.
I do agree with that. But there's been other case law, Your Honor, where if you look at, for example, where their sanctions were not ordered, if you look at the Braley case, which is one of the first cases that came in, despite the 10th Circuit not understanding the brief or the arguments that were being made, the lawyer was relieved of sanctions. And when you look at even some of the other cases in terms of where sanctions were ordered, for example, in the Hamilton versus Boise Cascade case, where the fee award was affirmed, it was very clear that the lawyer in that case knew that the other lawyer disagreed with his position and yet never made a correction. So that's not the situation that we have here, Judge Kelly. The situation we have here is that Ms. Gokenbach relied on an order
But
and she did not.
Counsel, if that order had nothing to do with the situation existent in this case, was the court totally out of line by saying this is a frivolous argument and you should know better and therefore I'm going to sanction you? Is that an abuse of discretion?
I believe it is an abuse of discretion, Your Honor, in this case, because Ms. Gokenbach was relying on an order that she believed did apply.
Well, I know,
and
but
she believed it was broader.
If she erroneously believed that, and if the judge looked at it and said, how could anybody think that, would that be an abuse of discretion?
Well, the court didn't say, how can anybody say that? Court didn't say that in her order.
No, the order had nothing to do with the imposition, it was her position after the order and after the arbitration had concluded.
Well, I believe what the court seemed to be upset about, or what the court did not like about the argument, is the fact that Integrated Associates had asked for arbitration and then got arbitration. And honestly, I don't think that the district court, ever even really addressed Judge Kane's order. I think the district court's position was, you asked for arbitration and you got arbitration.
Well, she went beyond that. I mean, it wasn't just you asked for it and you got it. You participated in it without mentioning or challenging the arbitrator's ability to arbitrate the wage claim. Then you waited, got a decision you didn't like, and then said, oh, wait, you don't have authority to decide that claim. I mean, whether you had the prior order from the court or not is irrelevant to the fact that you just participated without calling the attention to it and then later challenged it. I have a hard time finding an abuse of discretion under those facts.
Well, as Ms., and I know I'm past my time, but as Ms. Gokenbach raised it in the other case, it was raised on the counterclaims when there was an argument about the frustration.
There wasn't an argument ever, and we've looked carefully at it, that, hey, arbitrator, you can't arbitrate the wage claim because of this prior decision by this other court. Just providing as part of the materials a copy of the order is not bringing that to the arbitrator's attention.
All right, I believe I'm out of time.
You are out of time. We appreciate your argument, and we'll turn to opposing counsel.
Okay, thank you.
Good morning again, and may it please the court. I will endeavor to be as not repetitive as possible here. On the issue in this appeal, it's important to remember that the Federal Arbitration Act imposes a high bar of review to vacate judgments. It's among the narrowest standard of review known to law. Integrated Associates, through Ms. Gokenbach, fell short of that bar in the motion to vacate. As the district court found in its order, the motion was in essence just an appeal of the arbitration award. And the court also found, quote, that Integrated Associates failed to even allege, let alone prove, any of the grounds enumerated under the Federal Arbitration Act. There's also a high standard of review for the award of attorney's fees in this case. As the panel has identified, that standard is abuse of discretion. Ms. Gokenbach has fallen short again of showing that this opinion, in order by the court below, rises to the level of an abuse of discretion. She's unable to show that the district court misapprehended the law or there was any errors in the factual findings that the district court relied on. The standard under 1927 does not require a finding of bad faith, nor does it require a finding that Ms. Gokenbach did not subjectively believe that's what Judge Kane's order says. It imposes an objective standard, and I think this court put it pretty well in the Hamilton versus Boise case when they pointed out that an attorney can be awarded fees even if they proceed with a good heart but an empty head. It's not enough to show that Ms. Gokenbach wanted to make a good argument, wanted to vigorously advocate for her client, and believed it was correct. The question is whether a reasonable attorney would have advanced that argument. And the courts are allowed to demand that attorneys research the relevant claims before submitting them.
So, counsel, I think that Ms. Gokenbach's brief on this issue addresses your last point in this way. I think you can find it on page 18. And as I understand the argument, that there's more than one way to read Judge Kane's order, and both ways are arguably reasonable. And one way is that the Wage Act claim is exempt from arbitration, period. And the other way is that the claim is exempt from arbitration unless Mr. Pope consents otherwise. That's the way it's put in the brief. So, as I understand the argument, it's that, well, even if we were wrong, we weren't unreasonable and shouldn't be sanctioned under those circumstances. So, why isn't that a good argument?
Because the interpretation of Judge Kane's order was not reasonable. Of course, if this court makes a finding that it is reasonable, I think we'd probably have to concede that an award of fees was not appropriate. However, I think it's very clear that Judge Kane's order was subject to only one interpretation. That there are two possible readings doesn't mean there's a reasonable interpretation. In the contract context, it's well recognized that a contract is not ambiguous just because one party can construe it in a way that differs from the other parties. That's not enough to show an ambiguity. There has to be enough that goes further and shows that the ambiguity is premised on a reasonable disagreement that actually changes the meaning of the contract. And I don't think that's present here.
Weren't you also arguing that the time that you, the Pope lawyers, spent on these issues, I believe there were 4 issues raised. One of them was this jurisdiction issue, but that the bulk of the time really wasn't even spent on this issue. But it seems like the arguments this morning are pretty much turning on it. Are we a little too focused on that, or what? Why aren't you pushing your other argument?
Well, I think, Your Honor,
maybe you were about to.
Yeah, and also that during the last argument, I kind of started to touch on that as well. I do think that's important because the court awarded fees that covered the hours of responding to all the arguments. Perhaps if this argument is found to be reasonable, the scope of the arbitrator's authority, then the court could, on remand, decide to disallow the fees related to that argument, but still allow the fees related to the other arguments. I don't think it's particularly persuasive that Ms. Gokenbach's now asserting that it's only the one argument because that argument would overturn and vacate the whole award, so all 3 of those other arguments are irrelevant. Those 3 arguments were brought at the district court level, and if they were wrong on this one, they brought those so they could then fall back on those other 3 arguments. So I think Mr. Pope...
Are you suggesting that every time somebody loses, they should be sanctioned?
No, not at all, Your Honor. I think
Pretty good rule.
Can you repeat that?
No, I say, are you arguing that, just because I have a firm belief that I'm right and you're wrong. And turns out you're right and I was wrong. Should I be sanctioned?
Not at all, Your Honor. I think there needs to be particular guidance and, a clear disregard for standards. And in this case, it's the very exacting standard of an arbitration award. I think it's important that this court has issued multiple warnings in the context of arbitration awards that it will issue attorney's fees against parties who adopt a never say die attitude. And that's precisely what's happened here. It was bringing everything that was possible to overturn or at least minimize Mr. Pope's award of damages from arbitration. And Ms. Gokenbach has the benefit of those opinions, the Lewis decision, as well as the DMA International decision being decided by this court almost 15 years ago. It's perhaps analogous to the qualified immunity argument this court heard this morning. She now has the benefit of that being clearly established by multiple opinions issued from this court. And I think she's fundamentally trying to get a new she's trying to get a new trial on the issue by winning the motion to vacate. It doesn't matter that she filed it as a motion to vacate rather than filing a separate complaint, in part because it wouldn't make any sense for her to file a separate complaint because the claim belongs to Mr. Pope. That's the distinction they've been trying to draw between the Lewis case and this one. But again, the Lewis case didn't have the benefit of the Lewis opinion. And I think it's also fair to note that the award of fees is not considered an extreme remedy. It's considered a relatively mild remedy. It's not an entry of default. It's not an entry of adverse factual findings. It's not anything like that. It's simply intended to compensate Mr. Pope for the fees he incurred responding to unreasonable arguments. And I think it does matter that Judge Kane's order is not subject to a reasonable interpretation in this context. The argument began as an analogy to subject matter jurisdiction, and brief research into whether the concepts of subject matter jurisdiction in the context of courts of limited jurisdiction applied to arbitration would have revealed that's not the case, and that arbitration in arbitrator's jurisdiction is decided as a matter of contract. And I think if there's any doubt about the possible interpretation of Judge Kane's order, then it's logical to simply preserve that argument. Otherwise, you're taking the risk that's posed by exactly this case, that by failing to raise it, you have actually waived it. And I don't think failing to raise it was a mistake. It was an attempt to keep this trump card in the back pocket in case integrated associates lost. If it had been preserved for review, this case would be entirely different. And I think that's important. The question isn't, was it reasonable to interpret Judge Kane's order one way? It's, was it reasonable to sit back in arbitration and let the whole thing happen without ever raising the argument? Those are two different concepts. Perhaps there was a reasonable basis to contest the scope of the arbitrator's jurisdiction, but the proper way to do that is by starting with raising it. I'm not aware of any authority that specifically addresses a party allowing a party to sit back and await the results of the arbitration before objecting to the scope. And again, it's important here again that integrated associates is the one who asked for arbitration. They got what they asked for here, and they shouldn't be allowed to now change their minds simply because they lost. And Ms. Gokenbach's argument has constantly evolved on its legal basis in this case. It started in the district court briefing as being phrased in the context of subject matter jurisdiction. It's now evolved into being argued on the principles of preclusion, whether it's correctly called law of the case or issue preclusion is immaterial. That was not the framing of the issue or the legal issue brought up in front of the district court. And I think that shows a recklessness, at least, towards what the standard was here and how valid those arguments were. Reasonable counsel would have looked at those first and established these reasons for the appeal below. They wouldn't be constantly trying to find new bases that keep accumulating and do not support the original argument. And turning to the issue of a hearing or separate motion on the attorney's fees, as Judge McHugh pointed out, there was, in fact, a separate motion. But there was not only a separate motion filed by Mr. Pope, there was a motion for reconsideration filed by Ms. Gokenbach. And the district court denied that motion to reconsideration and expressly noted that Ms. Gokenbach filed 23 pages of arguments on the issue of fees under 1927 alone. And the court expressly acknowledged that it considered those arguments before it awarded Mr. Pope his fees. In other words, Ms. Gokenbach had every opportunity and was, in fact, heard on the issue of attorney's fees twice over. That decision is within the district court's discretion. This court should not second guess such a minor procedural error that stems from the local rules of civil procedure. They're also pointing to Judge Arguello's own practice standards, and this court should definitely defer to Judge Arguello on her interpretation of her own rules. The second point that supports an award of fees, even absent a separate motion or hearing, is this court's decision in the Dominion video case. The Dominion video case presented the exact facts here. Can a party be awarded fees under 1927 if they only request those fees in a response brief? The Federal District Court for Colorado in that case awarded fees based on that response brief. And then this court affirmed that decision on appeal. It held that because the attorney in that case had the opportunity to be heard, the basic requirements of due process were satisfied. And that's all that needed to be satisfied in order to protect Ms. Gokenbach, or the attorney in that case, from deprivation of their right to be heard. And unless there are any other questions from the panel, I'll yield the rest of my time.
Thank you, counsel.
Do we have any rebuttal left?
No rebuttal.
Okay, can we ask for supplemental briefs on this subject matter jurisdiction issue?
I think that both Judge Kelly and Judge McHugh raised some questions about subject matter jurisdiction, and I expect the court will be asking for some supplemental briefing. Panel will confer about how to go about providing some direction on that, but just wanted to put counsel on notice that that should be coming soon.
And I would like to call the council's attention to the March 31st, 2022 case by the United States Supreme Court in Badgerow versus Walters, which deals with arbitration and confirmation or modification of arbitration awards. And in particular, I referenced the petitioner's first amended application to vacate, or on the alternative to modify the arbitration award, where it's pled that Integrated Associates of Denver is a corporation in good standing under the laws of Delaware. The Integrated Associates is no longer doing business, but it's registered conduct business in Colorado with a principal place of business located at 100 Fillmore Street, Suite 500, Denver, Colorado. Mr. Pope is also a resident of Colorado, and if that causes a problem, it's going to be a subject matter jurisdiction problem. And I just point that out in the event you are interested in briefing it.
Okay, thank you. Thank you, Judge Kelly. At this point, we will consider these two cases, 21-1019 and 21-1319, submitted after oral argument. We thank counsel for your appearances and arguments this morning, and counsel are excused. Okay, our next case is Rocky Mountain Peace and Justice Center versus United States Fish and Wildlife Service, number 21-1310. Counsel, you may proceed.
May it please the court, my name is Randall Weiner. I'm counsel for Appellants. In my 35 years of practicing environmental law, I've never seen an environmental analysis under NEPA so incomplete. I'm going to address the decisions of the U.S. Fish and Wildlife Service to put a trail through the Section 16 parcel. I'm going to request supplementation of the record. I'm going to address segmentation, and I'm going to address placing trails through the windblown section of the refuge, the most highly contaminated portion, without any written analysis whatsoever. At the end, I'm going to request, and actually I'm requesting now, that this court vacate the decision of the Fish and Wildlife Service, that it remand that it tell the agency, instruct the agency, that if it wants to keep the additional trails open, that it prepare a complete environmental assessment. I'm going to request that you take judicial notice of in the interest of justice, of the 2 attachments to the opening brief, which explain that my clients submitted to the Fish and Wildlife Service comments regarding the migration of plutonium, the Kaltofen study, and the Cook v. Rockwell jury verdict form, and yet the agency did not include that in the record. They buried it under the rug. Let me start, Judge Matheson, if I could, by pointing to the fact that in your decision in Watersheds Project, the 2013 decision, you noticed that under the normal course of events, a NEPA analysis starts with an environmental assessment, and then if there's a FONSI, a finding of no significant impact, then a full environmental impact statement is prepared. That wasn't done here. In this case, the Fish and Wildlife Service availed itself of what should be a seldom used technique to avoid NEPA analysis called a categorical exclusion, based on the notion that putting trails where it did in 2018 were minor changes from what was done previously as analyzed in a previous EIS, but they weren't minor. They weren't minor because one of the trails went through the Section 16 parcel, which was acquired in 2010, long after sampling was completed, long after the cleanup of Rocky Flats occurred, that 1 mile of trail went through this section of the refuge and was never, these lands were never analyzed for plutonium contamination. And even more significant—
The land that was acquired from the state?
Yes, it was acquired from the state.
Wasn't it examined carefully for plutonium issues at that time?
Not in the slightest. It was examined using a phase 1 analysis. In real estate, you take a look at issues. There was never any examination of radionuclides. And that was significant because during the preliminary injunction hearing in this case, there was testimony from witnesses that suggested that there was a white barrel halfway submerged in a lake in the middle of the Section 16 parcel.
Well,
and
they said you have to take the barrel out of there, but that didn't prove anything.
We don't know if the barrel was taken out other than it isn't there now. There was no sampling of the barrel. There was no radionuclide sampling of the lake. And there was no sampling of the 644 acres comprising this Section 16 parcel.
Well, that wasn't even part of the original nuclear plant, was it?
That's correct. It wasn't. So the Fish and Wildlife Service acquired it basically squared off the corner of this square refuge. It acquired that land in 2010, Judge Kelly, and then, and that was 5 years after the EPA had conducted any sampling. So the agency made its decision without knowing if it was placing a bicycle and hiking trail onto land that may have been contaminated, which really is kind of a no-brainer to do sampling because it's next to one of the most highly contaminated areas in the country, this
Well,
Rocky Flats.
Correct me, I was under the impression that the Colorado Department of Public Health and the environment and the EPA groups determined that the risk to construction worker in that area was at or below the low end of the applicable risk range. Is that incorrect?
It's incorrect because apparently the government did something that was a little hazy here. After we filed the suit and after it made its decision, it did some sampling in 2019 without telling us so we could take split samples. In 2019, a year or more after the agency made its decision, it did some additional sampling on this Section 16 parcel. But that's dirty pool. The government can't come in after the fact, do some sampling, and use that to justify its decision. Are you reading from the footnote in the response brief?
Well, I was under the impression that in 2011, the service issued an environmental assessment specifically addressing Section 16.
It did. It did, but it didn't.
And did anything happen in between there that would have affected it between 2011 and now, or in 2019?
The 2011 environmental assessment, Your Honors, did not deal with placing a trail onto potentially plutonium contaminated land. It was just an acquisition environmental assessment. Here, the actions we are challenging are the placement of trails and opening to public trails.
Well, that's the Greenway.
That's the Greenway and
It's just that one segment.
No, it's also a 1 mile of trail through this Section 16 parcel. So, the
Well,
action.
Counsel, let me just to make sure
Yes.
we have full context.
Of course.
Didn't the environmental assessment in 2011 include a contamination survey that was closer to the industrial area than Section 16? Isn't that what the service was relying upon?
I don't believe that those are what the facts are. The service acquired the land in 2010, 5 years after the Rocky Flats cleanup had occurred, 5 years after the last of the samples were taken. They did an environmental assessment, but they never addressed the radionuclide issue.
Well, again, maybe I'm not understanding their argument. We can hear from them later, but I thought they were arguing that they had done a contamination assessment on land closer to the industrial area than the Section 16 parcel, and that's how they're justifying what they did in the 2011 environmental assessment. Now, I don't know whether you may not agree with that, but isn't that their position?
I believe so. They may have taken a few samples that were a little closer to Rocky Flats than the Section 16 parcel.
Could I just ask, in terms of, you raise a whole lot of issues here.
I do.
In terms of the order in which they should be considered, I've got a question about the categorical exclusion piece of all this. And you're arguing that there were extraordinary circumstances that should have prevented reliance on categorical exclusions in the 2018 EAS. Now, if we disagree with you on that, and I don't know at this point where any of us may be on that question, but if we did disagree with you on that point and the categorical exclusions stand, then what's left after that? I guess what I'm getting at, it seems like there's some overlap in these arguments, and it seemed to me that maybe that one was a place to start, because depending on how that one turns out, it could affect your other issues.
You know, this case was brought under the Administrative Procedure Act, and under the State Farm Standard, if the agency overlooks a significant issue, then it's acted arbitrary and capriciously. And that happened here, and that's why we're asking you to supplement the record. The agency received information regarding the dangerousness of plutonium after 2004. They received the Kaltofen study, which showed much higher levels of radiation. They received the Cook v. Rockwell jury verdict form, where a $900 million award
Well, that had
was
nothing to
awarded.
do with this area, though, did it?
Yeah, we believe it certainly does. Migration of plutonium from the central core, if you think of Rocky Flats as a donut, and the central core is still the Superfund site, and then the outer core is where the refuge is. Any migration of plutonium that goes to lands beyond the donut is also impacting areas of the donut itself. So yes, we believe it's important. What I was saying about
Did you provide any information to the district court showing that the service had the Kaltofen study and the Cook jury verdict form?
No, we didn't. We did not get those materials until our clients looked through their records and saw they had actually submitted them to the service. But what's interesting—
And neither of those is a public record, is it? They're not a traditional public record.
One was I don't know what you mean by public record. You mean, can you find them in the—
Well, public records, as we typically require in order to exercise judicial notice. They have to be not subject to debate, among other things.
In the one case, the seminal case dealing with supplementation of the record is the American mining case, Judge. And in the American mining case, for the very first time in the Court of Appeals, the court took judicial notice of supplemental materials. One was a letter that was not in the public record. And the court does this based on, takes judicial notice in the interests of justice. And here, where the agency actually received these documents and buried them under the rug, this court should follow the American mining standards and accept them. There are two types of American mining documents. Pools of documents. One is where documents are needed to complete the record, and one is where they're needed to supplement the record. These two documents are needed to complete the record, as are the internal emails from the agency, which showed that the prior regime, the previous director, had a policy of keeping trails off the windblown area, the most contaminated portion. And those emails should have been in the record so that the agency could discuss and consider the previous director's policy. By excluding that from the record, the agency didn't have a complete record, and we ask you to overturn the district court and have these supplemented in the record. In addition, during the preliminary injunction hearing, there was testimony from witnesses. You talked, for instance, about that white drum, that painted drum. One witness said that white paint meant that it was a plutonium drum on its way to WIP. And those testimony witnesses were subject to cross-examination. There's an indicia of reliability. We ask you to supplement the record with those documents. And we're doing that because overall, really, in my 2 minutes left, what this case is about is transparency. And Judge Kelly, you yourself in your—
Counsel, time is flying, so let's try to get another question in. I'm back on the categorical exclusions. I don't think I really heard an answer to my question, but let me zero in a little bit on it.
Yes, sir.
As far as the highly controversial extraordinary circumstance argument based on controversy in opening the refuge to public hiking, wasn't that addressed in the 2004 EIS? Seems like you're trying to relitigate something that happened more than 15 years ago.
Well, it wasn't. It was a current dispute between Broomfield, Superior, and Westminster as to where the access point would be on the eastern side of the refuge.
Well, did you present that argument in district court?
Yes, both in district court and your court, and we argue that
Wait,
highly.
in our court?
I'm sorry?
You mean in your appeal now?
Yes.
Yeah, did you present it to the district court?
We did, Your Honor, and we argued that it was highly controversial with respect to the fact that these three cities were vying for a different access point, and that goes to the, and this was.
Just because cities are vying for an access point, why does that become highly controversial?
Because.
Just because there's debate over something doesn't automatically make it highly controversial for purposes of the categorical exclusion.
Highly controversial has been interpreted by courts not to mean the public is up in arms against you, up against it. You're right. What it has been interpreted to mean is that it impacts the size, nature, and effect of an activity, and where the location is goes into the size, nature, and effect. Even worse, Your Honor, is that there's no paper trail. The agency made its decision as a categorical exclusion, and we have no way of knowing why they chose among competing access points, whether they did it for safety purposes. The lack of a paper trail makes this case arbitrary and capricious.
Thank you, counsel.
Good morning, Your Honors, and may it please the Court. Michelle Melton on behalf of federal defendants. I have some prepared remarks this morning, but first I would like to respond to Mr. Weiner's comments, both about the categorical exclusion, the categorical exception, and the Section 16 parcel.
Can you slow down just a hair?
I apologize, Your Honor, yes.
Okay, because I can hardly understand you. Just speak a little louder, thank you.
First, to your point, Judge Matheson, I agree with you entirely if you were suggesting that this is not the kind of controversy here that constitutes controversy within the meaning of NEPA, but I'd actually like to take a step even further back and say that any controversy over the eastern access point in the refuge is not at issue in this action. As the 2018 Environmental Action Statement clearly shows, the service exempted or accepted both the eastern portion of the Greenway and the eastern access point from this action. That was to be, the decision about where to put that entrance point was not yet made at that time, and was, the service is consistent.
Well, this goes to the segmentation argument, doesn't it?
As I understand it, he was arguing in the context of controversy, but I'd be happy to also address segmentation.
But we're also talking about taking the trail modification in the windblown area is outside of, isn't your position that was not decided? There's no planned action in the 2018 EAS.
The service had not decided at that time to move forward with that portion of the trail or the eastern access point.
As I understand the argument, that was an improper, at least the argument is that was an improper segmentation.
One of their arguments is that was improper segmentation.
Well, why wasn't it? After all, this is supposed to be an integrated, interconnected trail system, and the 2018 EAS actually mentions it, probably mentions the windblown area trail more than the other trails, at least in writing, and yet it's not, all of a sudden it's being pushed aside and said, well, we'll apply NEPA to that down the road, but why is it reasonable to carve that out?
Well, I have two responses, Your Honor. The first is that it wasn't, the agency, when it initially made its plan for opening the refuge to the public in its 2004 CCP and EIS, examined all of these trails. I want to be very clear that there are no safety issues, whether it's in the windblown area or not. The service examined all of that in the 2004 CCP EIS and decided that it was okay to put those trails there. I would say that that alone defeats the segmentation argument. However, if Your Honors are not persuaded by that, I would say the test in this circuit for whether two actions are connected is the independent utility test. And the question is whether the trails that the service decided to move forward with have independent utility from the eastern access point and the eastern part of the Greenway. And the answer to that, Your Honor, is I think unequivocally yes. These trails are in use today 40,000 visitors visited the refuge in the year 2020, enjoying these trails. I think that that itself speaks to the independent utility these trails have, whether or not there's ultimately a connection built, which I should add to correct the record. They have not yet been built, and there's been no final decision about them. Turning, if I may, to the Section 16 parcel, Your Honors, I just want to clarify a few points about that parcel, both about how it was acquired, what the prior environmental analysis was, and just how that has come to be. The Rocky Flats Act, Section 3174, provides for 300 feet in the east of the refuge to ultimately be sold or given away as for transportation improvements along Indiana Street. The service talked to its local partners. They ultimately proposed a land swap, land on the eastern portion of the refuge in exchange for the Section 16 parcel. At the time, Your Honors, nobody, and I truly mean nobody, thought that there was any concern about plutonium on the Section 16 parcel. It had never been part of the Rocky Flats site. Geography demonstrates why it would not be. It is upwind of the site, so when the wind blows from that central hole of the donut, to use Mr. Weiner's analogy, it blows to the east.
But there was no contamination assessment of the Section 16 parcel, correct?
That's not correct, Your Honor. There was a contamination assessment of the Section 16 parcel. What there was not was actual soil samples taken on the Section 16 parcel itself. And the reason for that...
Well, could you just
Let
explain...
me interrupt.
Could you just explain the difference between contamination assessment and soil samples?
Sure. Anytime that a parcel comes into, or anytime land comes into the service's jurisdiction, prior to accepting jurisdiction, the service conducts a broad-ranging analysis of what possible contaminants are in the area. That's not just radionuclides, it's also any kind of hazardous chemicals or hazardous waste or just debris that is in the area. And so this assessment was looking at all of those potential environmental contaminants, not limited to plutonium. Although, of course, plaintiffs are concerned about plutonium here, that was not the only thing that the service looked for when it assessed the site.
And that was a phase one? Is that the phase one you're talking about?
Yes, Your Honor, that's correct.
Okay, and so that would be primarily a historical record of how the property was used, but no soil samples actually taken.
There was water
Correct.
sampling. There was water sampling, Your Honor, but there was no soil sampling specifically for plutonium. And the reason for that was that the expert who did the assessment talked to a service land person who was very knowledgeable about the potential for plutonium contamination on the site, and also looked at the history of sampling, which occurred along the border with the refuge. And those samples were at or below background levels. And so I would direct Your Honors to the administrative record at page 1362. I think that makes it very, very clear graphically why there really just was no concern here, and why nobody at the time that a prior lawsuit over this land swap ever raised this issue. People were very, very concerned about plutonium contamination on the eastern edge of the refuge, which is where the wind blows, and as previous sampling had demonstrated, was an area of potential concern, but nobody had ever thought that there was any reason to believe that the Section 16 parcel was contaminated. And I would just add that even going back, EPA, when it initially defined the site, the Rocky Flats Superfund site, it did include both the central operable unit, which is the industrial area plus some acreage, as well as the peripheral operable unit, which is what now constitutes the refuge. There was another operable unit, which was operable unit 3, which was lands off of the DOE site. And those lands were included Stanley Lake. It was all of the lands to ranging from the northeast to the southeast. Those were the lands that the Colorado Department of Public Health and the EPA were concerned about. Nobody was truly concerned about contamination on the Section 16 parcel, which after all had never been part of the site, had been continuously used for mining, for recreation, for grazing. There was grazing on that land in the past. There continues to be grazing on that land. It was used for agricultural purposes. This just was not a concern, and the acquisition survey, I think, demonstrates precisely why, and was supportive of the service's decision to issue a FONSI in 2011, which I would add is not on review here. So it was not arbitrary and capricious, in our view, for the service to rely on that 2011 FONSI, which is exactly what the district court held.
Could I just ask on section 16, the proposal was to add a mile-long trail.
The 2018 proposal?
Right.
Yes.
All right, that's not a modification so much as it's a new trail. So why isn't that a significant new circumstance or an extraordinary circumstance?
Well, Your Honor, I would say two things to that. First, the 2011 EA did examine the possibility of bringing that parcel into the refuge consistent with the purposes and uses outlined in the 2004 CCP. So I think it was clear at the time in 2011 that everyone believed that the Section 16 parcel would be managed the same way the rest of the refuge was managed, which is for public use as well as other purposes. To your question of why adding a mile of parcel, or excuse me, a mile of trail on this parcel is not an extraordinary circumstance, the extraordinary circumstances are a regulatory, are outlined in the Department of Interior regulations. There's no regulatory provision that I think that this would fall into to make this an extraordinary circumstance. Appellants have argued in reply, for the first time in reply, that this is it presents unique or unknown effects. We think that it's improper for them to raise this in reply, since although it was an issue that they raised below, they'd abandoned it on appeal. But I would also just say, for the reasons that we've discussed already, there's just no merit to the argument that there were unknown or unique risks here. And that is the only categorical, that is the only extraordinary circumstance that would preclude the application of a categorical exclusion here.
Now, you've argued that Mr. Stafford's declaration and testimony weren't enough for standing on the Endangered Species Act claim, but do you have any question about the plaintiff's standing to make their NEPA claims?
Your Honor, we have not challenged their standing here. As I understand their argument, although this is a question that you, of course, can direct to them as well. As I understand their argument, they are concerned that the very minor activities contemplated by this EAS will kick up essentially dust, and that dust will entrain itself into the air and blow onto them. We don't agree as a factual matter with that, Your Honor, but we've chosen not to challenge their standing. I think it's a tough injury argument, and they also have not necessarily articulated precisely their theories of traceability and redressability, but it's not an argument that we have made, although of course we think that you're entitled to find that they do not have standing on any of these claims, Your Honors.
So you're not challenging standing?
As to the NEPA claims, we do.
I'm sorry, what?
As to their NEPA claims, we're not challenging standing. We do have concerns about their Endangered Species Act claims, standing for those claims, which I'd be happy to address as well. And I do want to correct perhaps some misimpressions or something that the other side said in their briefing. They cite the case of State of Utah v. Babbitt for the point that at a PI hearing, the standard is akin to the motion to dismiss stage. This court expressly reserved that question in that case, and we would argue and we believe that the standard is actually more appropriately the summary judgment standard, not the motion to dismiss standard. We think it ultimately doesn't matter because we don't think that they even meet the reduced burden under the motion to dismiss stage, but we nonetheless wanted to flag that for the court. I would also just point out as to procedural injury here, Your Honor, they make a lot about procedural injury. I just have 2 points in response. First, we don't actually think that there's a procedural injury here because in a Section 7 consultation, Your Honors, there's no procedural right to participate. It's an intragovernmental process, and we think there is no procedural right here. But in any event, we think that they are wrong when they say that a procedural injury alone is sufficient to confer some sort of a procedural violation is enough to confer standing. That is not how we read Spokio. We think the court was very clear in Spokio that there needs to be some independent injury, and we think here there plainly is none. Even accepting, if you do, that they have an interest, Mr. Stafford has an interest in raptors, we just don't see how any of the actions that the service has contemplated here could affect those raptors. And so we don't think that they have pleaded or demonstrated any concrete or any threat to any interest that they have articulated here.
Sounds a little bit like you're making the causation or regressibility argument.
You can characterize it any way you want, Your Honor. I think it does overlap considerably with the causation argument, but we also fail to see an injury, a threat. I think they've articulated an interest in the raptors, but we don't think that there is a articulated or plausible, as opposed to hypothetical, threat to the raptors that Mr. Stafford enjoys. I would also like to draw this court's attention to a case that was decided in September 2021, which also addresses some of the segmentation issues that you raised, Judge Matheson. That is Town of Superior v. Fish and Wildlife Service. It is an unpublished decision from the District Court of Colorado. It is 2021 Westlaw 4206425. Although we don't think it's obviously binding on this court, it does address many of the same issues, although not all of the same issues that were raised here. And so we think that that is persuasive authority that not just Judge Brimmer here, but also another judge against other, adjudicating claims against the service on the same action.
Is that cited in your brief?
It is not, Your Honor, and I apologize for that.
It might help just to send us a 28J letter. So
I would be happy to. I apologize for that, Your Honor.
I see your time has expired.
My time has expired. Thank you very much for indulging me this morning. I appreciate it.
Thank you, counsel. Thank you, counsel. Appreciate your arguments this morning. The case will be submitted and counsel are excused. The court will stand in recess until 8:30 a.m. tomorrow morning.